Yes.
Lordship, may I permit you to mention, your Lordship, regarding Group 6 application, your Lordship.
Group 6.
Application, your Lordship.
Group 6, we don't have.
Lordship, actually, Lordship, the bench specialized by your Lordship. Lordship, this is at Jalpaiguri, and at this stage, your Lordship, one contempt application is pending against me, and matter is. And actually, Lordship, Chakrabarti.
Group 6, it has to come before Justice Tapopatra. It has to come before the division bench of Justice Tapopatra Chakravarti. He is now in circuit. And his
Lordship, actually, question is here. Lordship, Parthasarathy Sen has passed the judgment, and thereafter, your Lordship, Parthasarathy Sen and Lordship Chakravarti sitting together, and due to this reason, that bench cannot be heard this matter.
Oh, then you give this letter to OSD, Officer on Special Duty.
And your Lordship, contempt is pending before the
single bench.
Single bench. Due to that reason, your Lordship, I am.
No. If the matter has to be assigned, it is released. I can assign it. You just give the letter. We'll call for the file and see what is the matter.
My lord, under compelling circumstances, my lord, may I have, my lord, leave to file and move an urgent appeal, my lord. The impugned order was passed yesterday, my lord. The single judge, my lord, has directed implementation of an order of an authority, my lord, from which I have a statutory right of appeal. The statutory right of appeal, the period has still not expired. This learned single judge yesterday, my lord, has passed the order directing implementation of that order without granting me an opportunity of hearing, my lord. My junior was there, my lord. He sought a passover, my lord. The learned single judge passed the order. Despite that, regardless, my lord, the order itself is without jurisdiction. The provision under which the authority has passed the order, my lord, is a remedial provision. It's under the Fire Services Act, whereby they can direct me to implement certain fire compliance regulations. Instead, the authority has rather directed me to stop my business altogether. 50 employees, my lord, a garment store running from a lawfully tenanted premises, my lord, is being stopped. The writ petition is also, my lord, to my understanding, as a third party who has been instigated by a developer in this property, seeking to evict me somehow from the premises and to develop it. My lord will kindly take it up at 2 p.m. My lord, the order has been directed to be implemented.
2 p.m. we have got original site.
My lord,
leave can be granted to file the appeal. Please
my
grant
lord,
leave.
Deep pleasure. My lord, could it appear on Friday? Could I only humbly beseech, my lord, or else the order will be implemented, my lord? My business.
File it today. You file it today.
Obliged.
You have applied for certified copy?
I have applied.
Date of order?
Already 25 January.
Leave grant.
Just kind of to mention a matter, your lordship. This is a pending appeal which was being heard by the bench of Justice Tapobrata Chakraborty and Justice Rajavasu Chaudhary. Now, certain urgencies arise and we have filed an application. Now, since that bench is not sitting, my advocate and record in the circuit bench yesterday mentioned. Now, Justice Tapobrata Chakraborty said that since the bench is not sitting, kindly go and request before the Chief Justice so that it can be assigned before the regular bench, which is now being taken up by Justice Shobhan Sen and Justice Vishwarup Chaudhary.
Give the letter to OSD.
Great. Great.
My lord, I'm seeking your lordship's kind leave, my lord, to file and move an urgent, my lord, intercourt appeal, my lord, of an order which was passed day before yesterday, my lord, in which a tender matter relates to a tender, my lord. My lord, the urgency is, my lord, during the pendency of the writ petition, my lord, financial bid has been opened. But the latest statistics is that, my lord, a work order has not been issued, my lord. Despite that, my lord, there are interveners, my lord.
Server copies available.
Server copies
Yes, leave grant.
My lord, may I come back any date subject to your lordship?
We will give that.
My lord, may I be permitted to mention a original side matter? My lord, in this matter, my lord, two persons have died in an alleged accident, but I am praying for transfer of the investigation agency. Once it has been transferred, the CID, my lord, has done the same thing, not answered any of the questions which I have raised. So, my lord, this bench has heard earlier, my lord, kindly it may be listed.
Yes.
Let me mention one matter. Honorable Justice Aniruddha Roy had released the matter out of his list. Milord, and only Honorable Justice Parthasarathy Sen has got the determination. The matter has been appearing before NGT, National Green Tribunal, and I tried to intervene in that matter. The next date is coming in the coming month of March, your lordship. Kindly fix a date, name, any day coming week or in the next week.
Yesterday, one of the matters which was released by Justice Roy, I have assigned it to somebody. I don't know whether this is your matter.
No, Milord, not this one. I guess because it's.
Give a letter to the OSD. We'll see.
I'm obliged. I'm obliged.
No, to the OSD you give it.
I will.
Yes, please call.
Appellate side daily list serial number 1.
Now, have you fixed a date for the meeting?
Milord, we wanted to. Milord, we wanted to have it on the Thursday, Milord. Now, what the difficulty has become, the state government has given a holiday. We are fixing it on Monday, 5:30
But in
today.
the meantime, an agricultural department site, why did you dismantle?
Irrigation department, my lord, I had, my
Irrigation
lord.
department.
Milord, I have been given three serial numbers of the list which was provided. I have taken instruction, Milord. Monday, when the matter was already been taken up, the dismantle procedure had started. So only three we had to dismantle because it was in halfway. Rest, we are not doing anything. We will do it only after Monday, Milord.
All right, we'll record that and.
Yes, my lord, that note, my lord, till the hearing, my lord, no further
But, Milord, there is
dismantling.
another difficulty the commissioner is facing, Milord. As the matter is there, Milord, we wanted to point it out, Milord. What has happened, Milord? The society which is before Milord's is the organization of the society, the managing committee, is not updated since 2011-12. So the present governing body, which is before Milord's, is not recognized by the government under the Registration of Societies Act 1961. So, Milord, who is to represent, whether they are the right body or not? We have written to the government.
But then they have filed a writ petition. They filed a.
Milord, in Supreme Court, we took that point. Supreme Court also we took that point.
Either the association or, my lord,
Milord,
individuals, my lord, all.
see the communications we have between the government, sir, the government and the corporation, Milord. What happens is we do not know that who is the society. Milord, will kindly see the
But
second
at
part.
least if the office bearers are continuing, they should be informed. I mean,
Yes, my
Milord,
lord,
that is also a
intimate them.
problem. Milord, will kindly take up the affidavit page of Can 7. Milord,
no,
which
we are
is-
not hearing the matter today because to ensure what could be done with regard to this particular applicant alone, we wanted to do. All right, let
No,
the
Milord, the
meeting be
difficulty
convened
is,
on.
Milord, some other people are coming up now and saying we are the society. We don't know who are they. Now here somebody called Deepak Kumar Sharma says I am the secretary. The government record says that the secretary is. Milord, will give me one moment time.
Okay.
Sorry. Some Neeraj Paul is the secretary as per the government records. I just pointed out.
Okay, Neeraj call, okay. Who is Neeraj call?
No, please sort out.
I'll sort, my lord, I'm told, my lord, Deepak Sharma is, my lord, one of the office bearers. And, my lord, who's the secretary?
Milord, Deepak,
My lord,
Deepak
Anindo
Sharma
Banerjee
was the
Chaudhary is,
secretary.
my lord, the
They
secretary.
said they are the secretary before the Supreme Court. But according to government records, Mr. Nirmal Thakur is the secretary.
No.
And we have the written communication of the registrar of the societies. Milord, as the commissioner, I do not know whom to ask.
No, then the association has to nominate 3 people.
Very well, we'll do that, my lord.
Milord, subject to correction. Let the association first regularize themselves before the government. Now, after 2011-12, they don't exist.
Oh, why have you not filed your returns, the
My
association?
lord, quite often, my lord, even after it's filed, it's not updated.
Milord, after 2018, everything is online.
I'm
There is
sorry,
no
no.
chance of missing.
My lord, even in the case of, my lord, the IGNU, my lord, the Golf Union, my lord, it hadn't been updated.
All right. Matter has been listed under the caption to be mentioned at the instance of one of the advertising agency alleging that that in spite of the earlier order directing a meeting to be convened by the office with the office bearers of the advertising agency, the authorities have dismantled 3 hoardings which have been erected with permission inside.
My lord, 7 hoardings, my lord, we have the list.
3 has been dismantled.
7.
Milord, I have taken 3 instructions because 3 was provided to us by the advocate. No, I'm Jani na, আমাকে 3 দিয়েছিল, আমি দেখিনি।
Which have been erected with due permission from the irrigation department. The learned advocate appearing for the state submitted that the dismantling process began much earlier.
For the corporation. Advocate for the corporation.
Advocate for the Bidhannagar Municipal Corporation submits on instruction that the dismantling process began earlier. And after the order was passed by this court on 10th of February 2025, the municipal authorities have not proceeded further. This submission is placed on record. One other issue which has been flagged by the learned advocate for the Bidhannagar Municipal Corporation is that as per the government records, the
Last annual return is 2012-13.
the last annual return filed by the Outdoor Advertising Association was for the financial year 2012-13, and thereafter they have not complied with the requirements under section 16 and 17 of the West Bengal Societies Registration Act 1961. Therefore, it is submitted that there is a confusion as to which of those persons who are entitled to represent the Outdoor Advertising Association. The learned senior advocate appearing for one of the advertising agencies submitted that many a times, despite filing of returns and requisite documents, the same are not uploaded. This submission is disputed by the learned advocate appearing for the municipal corporation. Be that as it may, if the annual returns have not been filed, the association should promptly do so and get the records updated. However, in the meantime, since the meeting has been scheduled on 17th February 2025 in terms of the earlier orders
At 5:30.
at 5:30 p.m. In the office of the Commissioner of the Bidanagar Municipal Corporation, the association, namely the Outdoor Advertising Association, shall nominate 3 persons.
My lord, we have in our representation, my lord, page 452, my lord, the 3 names are given.
3 names, and the same shall be submitted in writing in the office of the Commissioner of the Municipal Corporation by 3 p.m. today. Let the meeting be convened on 17/2, and the minutes of the meeting be placed before this court on the next date.
And my lord, the writ petitioner, my lord,
In personal
my
matter.
lord, may.
That was granted on the last order.
It was also directed that he should be there. My lord, one legal representative from our end as well.
The writ petitioner who is appearing in person shall also be invited to the meeting. Apart from that, the advertising agency can be represented by learned advocates, numbering not more than 3.
And my lord, in the meantime, my lord, no dismantling till the hearing.
That will cause a lot of problems, sir. Initially itself, we have not granted an.
I know, my lord, just to.
So therefore, we have made recorded a submission that they have stopped work.
Very well, my lord, kindly just.
Only one sentence, my lord. When the agency comes before us, my lord, let them bring all requisite documents. Or else they will later on say.
Needless to state that when the advertising agencies are represented in the meeting convened on 17th of February 2025, all documents which are in possession of the advertising agency should be placed before the commissioner. Next.
Serial number 2.
All day documents relating to the holdings.
That is my
I am filing my affidavit of service. The appeal before your lordship is against the order impugned dated at page 85 of my stay application. And first of all, my lord, your lordship, there is a delay of filing the appeal for 83 days. Because, my lord, initially the poor person, my lord, and after obtaining the certified copy also late, and she has to take the decision of preferring an appeal against that order. And for that reason, it was a delay, my lord.
How many days delay?
83 days.
All right. Now, what is the court has recorded, placed on record a report of the Commissioner of
Yes,
Police.
my lord. The report is also in my annexure, my lord, at page, say, 80, starts at 80, my lord. My lord, only before your lordship comes to the report, I'm just.
What was the prayer in the writ petition?
Writ petition was the person, the SI. The writ petition is also annexed in this writ petition, my lord. That is prayer is at page
45.
45. My lord, the main
Stern
response
and
was
prompt
this.
action against the 7th respondent.
Yes.
Involved in the matter, police brutality.
Brutality. My lord, for this to establish this thing, my lord, your lordship, please come to my photographs, which I have annexed
Yes,
in this
yes.
writ petition,
There is a policeman trying to beat a lady.
a lady, without any lady police. The policeman came before the inside the courtroom, inside the premises, and beaten up by lathi, my lord. The lady is also here, my lord. If your lordship so pleases that, and the allegation in the report is that that lady with a bamboo stick tried to attack the other person. So that is not possible, my lord. It is not possible at all. My lord, your lordship will, page 81, the report says that from the statement, medical document, lady police personnel and CCTV footage, it is no lady police personnel was there. They are outside the premises, my lord. It is clear that
Then you do one thing. You lodge a criminal complaint.
we have already filed a appeal, my lord. FIR has been lodged, but no steps has been taken.
No, where is the copy of the FIR?
My lord, copy of the FIR, my lord. It is a FIR number is there.
Where is the FIR number?
My lord, in my
The commissioner's report says that there were two sets of people who were quarreling with each other.
and the suit is pending.
Suit is pending.
And injunction order is also there. During the period of the injunction order, they have tried to install a collapsible gate. That was the main purpose.
Where is the FIR number?
My lord, FIR number initially, that is at
No,
page
you
7.
please come to page 80.
80.
There are three cases.
Yes, yes.
Case number 264, 374, 375.
Yes, my lord.
Which is the complaint lodged by the writ petitioner?
Just a minute. My lord, our FIR is FIR number 264 of 2022.
All right.
Dated.
This intra-court appeal has been filed against the order dated 16/2/2023 in WPA 27781 of 2022. There is a delay of 84 days in filing the appeal, and an application for condonation of delay has been filed.
83 days.
83 days. And we have perused the averments therein, and as sufficient cause has been shown, the delay in filing the appeal is condoned. The respondents have been served, and affidavit of service has been filed on record. Full stop. None appears for the respondent. The petitioner sought for action against the seventh respondent in the writ petition,
Yes, sir.
who was impleted by name, who was functioning at the relevant time as the sub-inspector of the Golabari police station.
Well, my main grievance is against that person, my lord, because
It is alleged that the seventh respondent exceeded his jurisdiction and had assaulted the writ petitioner with Lati. As a result, the petitioner seeks for stern action, sought for stern action against the seventh respondent in the writ petition. Before the learned single bench, the Commissioner of Police, Howrah, had filed a report dated 15th February 2023, from which it is seen that there is a civil dispute between the petitioner and the private respondents. And apart from that, private respondent, and a suit is pending in TS number 991 of 2022. Apart from that, the writ petitioner appellant has lodged a complaint before the Golabari police station in case number 264 of 2024, dated 3/7/2022, and a case has been registered under section 341, 323, 325, 506 and 34 IPC. Apart from that, there are two other criminal cases registered in the same police station in case numbers 374/22 and 375/22. Therefore, in order to consider as to the petitioner seeks for action against a police sub-inspector of police. Admittedly, criminal cases are pending in which it has to be established that the concerned sub-inspector of police exceeded his jurisdiction. This being a factual issue, cannot be adjudicated in a writ petition. However, since the petitioner has already lodged a complaint and a case has been registered in case number 264 of 2022, dated 3/7/2022, the same shall be
No, three
investigated
FIRs are there.
and taken to the logical end, and including the other two cases, namely case number 374 of 22 and 375 of 22, and the Commissioner of Police, Howrah, shall personally monitor the investigation.
Gratefully.
Needless to state that since a sub-inspector of police of the same police station is involved, it would be better to nominate a investigating officer who will be uninfluenced by any of the pressures that may be exerted on him, since the allegation is against another police officer. The above observation are disposed.
I'm grateful.
Next.
Serial number 3, Newton upon Ajay.
My lord, I am appearing for respondent numbers 1 to 5. This is that matter where nominee has, being custodian of the property, has usurped the entire property in her name.
But they are not appearing what to do. So if you dismiss this appeal, you implement the order passed by the single bench.
One latest development has occurred. The appellant has returned refunded rupees 2,66,277 to us.
Very good.
What was the direction of the honorable single judge? That part has been complied.
And which is the other part which is
The
required?
other part is that the private respondent number 6 was supposed to get the share of the property, 1/3 share of the property. That was not given.
Right. None appears for the appellant. Even on the last occasion, that is on 22/1/2025, none appeared for the appellant. We have heard the learned advocate appearing for the respondents 1 to 5. During the pendency of the, it is submitted by the learned advocate for the respondents 1 to 5, that during the pendency of the appeal, a sum of rupees
66,277
has been returned to the department. Correct?
My lord, my lord.
Returned to the department. This submission is placed on record. The appeal stands dismissed for non-prosecution. Next.
Serial number 4.
I'm grateful to Lord.
Serial number 4, Mr. Saktik Bhattacharya is appearing, my lord. I have been requested for a date, my lord, for a time, my lord.
Even earlier, they sought for a.
My lord, I'm not aware of this matter. This is a
And
request.
who will appear for the?
For the respondent. my lord. The repetition was dismissed at the threshold my lord, on the ground that since I have taken the point, the maintainability is a contractual dispute, so it's not maintainable. That apart, my lord, the other grounds are there that whether Calcutta High Court has the jurisdictions to entertain these present disputes and the repetition, that has to be decided, because as per the term and condition of the contract, my lord, the Honorable Guwahati High Court has the determinations and jurisdictions.
What was the prayer in the writ petition?
To set aside the order of termination of the tender. So tender had already been terminated in the month of July 2023. After termination of tender,
What is the remedy available under the agreement between the parties?
the arbitration clause is there.
You please show where is the prayer in the writ petition? Already twice it was adjourned, sir.
No, I am not briefed in this matter. I cannot assist, my lord. Only maybe a day's accommodation, my lord, then my lord will pass whatever order.
See, the thing is, same matters coming up.
I understand.
At the request of the learned advocate appearing for the appellant. No, though the request was made by the learned advocate appearing for the appellant to list this matter today, within bracket 12th February 2025. Today, once again, an adjournment is sought for on behalf of the learned advocate for the appellant. List the matter after 8 weeks.
Obliged.
Next.
Serial number 5. I am for the appellate. But this is the matter, my lord, of petitioner grievances for not issuing the ST certificate, and also my lord, specific grievance against the my lord, respondent authorities for not hold the field inquiry, which is very much
No, last occasion,
My
we
lord.
directed the.
Yes.
My lord, kindly takes up the last order dated 22nd of January, my lord. In that order, my lord, there is perhaps a typographical error. Your lordship was pleased to direct me to produce the department order numbers 390/CRI dated 13th of May 24,
My lord, writ petition of 2013, it will be of 2004, my lord. My lord, I have brought everything. It's of 2004, not of 24, my lord. My lord, may I place the records? দুটো আছে।
Any extra? You
দুটো
can
কি
give
আছে?
one
Patient
copy
দিতে?
of that.
No, I have copy. Patient দিতে? Patient
Now let me serve the copy.
No, there was no direction, your lordship, direct me to serve, my lord.
Now you
Yes,
can.
yes, I can serve, my lord. I have the copy. My lord, kindly consider flag 1 first, my lord.
Yes.
My lord, that is 13/5/2004. But as you are referring to, it will not will be 2024, it will be 2004, my lord. The report of the CRI. My lord, the inquiry starts at, my lord, 6th page, from the 6th page thereafter. As it's a report from the report, I have not marked it, my lord.
So inquiry has been conducted.
Conducted, my lord. And my lord, the last flag, flag 4, my lord, kindly consider, the BDO has also conducted the inquiry, my lord.
Well, I do not know, my lord. Let me come through the report, my lord. Because
No. See, for our satisfaction, we wanted the report.
Yes,
It
yes.
is clear. Your case
report,
is
my lord,
without
as per provision.
His grievance was there without any inquiry.
every third certificate is a fraudulently obtained certificate in state of West Bengal.
That is
In a
different.
PIL, we have issued notice as a result of
Yes,
which
yes,
more
yes.
than 300 certificates were
My
cancelled.
lord, if your lordship, my lord, kindly have a look.
No,
my lord,
no, no,
provision. Kindly have a look at provision. There is a section 8A.
That has been
Your
complied.
case was very simple, that without an inquiry, they rejected
Inquiry
your
must be held in a field inquiry by the screening committee.
field inquiry
has
has
been
been
done.
conducted.
Let me run through the, my lord, record.
No, no.
1 day accommodation, my lord.
We are satisfied, sir. This
Yes,
intra-court appeal is directed against the order dated 31/7/2024 in WPA 1420/2013. The appellant writ petitioner sought for a direction upon the respondents' authorities to enlist their names as scheduled tribe category. The writ petition was dismissed by the impugned order. Before us, when the appeal was heard earlier, the contention advanced by the learned advocate for the appellant was that no field inquiry was conducted and arbitrarily their prayer was negative. In order to satisfy ourselves as to whether at all a field inquiry was conducted before rejecting the claim of the appellant writ petitioners, we directed the relevant records to be placed. Accordingly, the Additional Secretary Law to the Government of West Bengal has addressed the subdivisional officer Chanchal, Malda, enclosing the copy of the inquiry report drawn by the director, Cultural Research Institute, wide memo number 390/CRI, dated 13/5/2004. From the report, it is seen that a detailed inquiry has been conducted. Apart from that, the block development officer, Ratua Roman 1 Development Block Malda, has also conducted a field inquiry, and a report has been drawn on 3/7/2008. Therefore, it is not a case where the authorities mechanically rejected the claim, but it is after thorough field inquiry. Therefore, we find no grounds to interfere with the order passed by the learned single bench. Appeal.
Well, only one in large is, my lord, the previous one, my lord, the date has been 2000. My lord, my duty is to point out before lordship.
Next.
Great, my lord.
Serial number 6.
My lord, I appear for the appellant, my lord. I'm being led by senior advocate Jishnu Shah, my lord. I just pray for a short passover, my lord. Very short passover, my lord.
Passover will be difficult for all of them. Today from 2 p.m. we have got original side.
My lord, I completely understand. Kindly just give me some time, my lord. A short passover, if it's convenient to your lordship, my lord.
Monday it will come. Monday.
Then,
Same position.
then, my lord, I'll start the matter then, my lord.
That's good.
Monday, I would have sought for an accommodation. Anyway, let's see.
Then it will come next Wednesday.
No,
Same.
my lord, the matter is actually urgent, so it is necessary to move it. I was just praying for a short accommodation for Mr. Shah, if it was possible.
Well, I'm
petition
glad
was-
they at least found the matter to be urgent. Well, after filing the, well, it's impugned order is of May 2024.
No urgency, sir. Matter was heard,
After
argued,
the application has been filed after 9 months.
and judgment was reserved. Hearing concluded on 13/5/2024. Judgment delivered on 22/5/2024. It is thereafter you filed an appeal. There was,
My lord, on,
What do they
on the
challenge?
last occasion,
yes, yes, you start.
very well, my lord. So, my lord, in 2015, 51% shares were of respondent number 7 were pledged to the bank, and the Amaya Resort, which is the subject property in this matter, the subject property was mortgaged. Now, this was for a loan of approximately, along with interest, it came up to rupees 90 crores approximately. Now, on 1st June 2019, the loan was declared an NPA, my lord. Now, the bank decided to hold an e-auction, and the e-auction was for assignment of the debt. Now, prior to me moving to the e-auction, my lord, kindly let me place the request to bid, that is the terms of the auction. My lord, will find that at page 158 to 176 of the appeal, my lord.
Yes.
My lord, the first clause at place is clause 2.2, my lord.
Yes.
By submitting the bid at the e-auction and upon being declared successful, the bidder shall be deemed to have agreed that the successful bid shall remain open for a period of at least 30 days from the date of submission of the bid, and Union Bank of India has absolute discretion to either to close the transaction of sale with the successful bidder, subject to the right to seek further improvement in the bid terms, or without prejudice to the above. The bank may withdraw NPA from sale at any time for any reason, including without limitation upon happening of the following events.
Yeah.
A, B, C, D, my lord. D would be relevant for a later purpose. Borrower is willing for negotiated settlement, which in the opinion of the bank is a better proposition. Now, my lord, so what is pertinent here is that a bid needs to be, the successful bid has to be open for 30 days. Now, my lord, I'll just state 4 relevant dates, my lord, as to how the bank has conducted this auction completely contrary to the terms of the agreement, and there have been misleading statements before the single judge, due to which the single judge has also erroneously passed the same order.
Yes, senior.
My lord, Mr. Shah.
With your lordship's leave, my lord, what is shocking is, my lord, that on the same date, my lord, the bank floats really 2, my lord, tender invitations. One is to sell the debt, that is to assign the debt. The other is to sell the asset, which is, my lord, the underlying security for the debt. Now, my lord, when the sale of the asset proceeds, my lord, there is no, my lord, bid received. My lord, the date is, my lord, 13th of February. We come to learn and we make an offer on the 19th of February.
13th February last year.
Last date. No, my lord, bids received. My lord, we come to know now, my lord, the SARFAESI Act, my lord, under Rule 8.2 now provides for, my lord, sale by private treaty. We make an offer. My lord, the offer is considered. My lord, my offer is 70.01 crores, which is in excess of the reserve price that is fixed at 68 crores. My lord, after that, my lord, my offer is in consideration. In the meantime, they proceed also to consider, my lord, an offer made by, my lord, another entity, which is an asset reconstruction company, for purchasing the entire debt along with this underlying security at 68 crores. Now, ultimately, my lord, I raised my offer to, my lord, 71.54 crores in the course of negotiations. They, my lord, steadfastly refused to accept my offers. And then on the 6th of March, my lord, much after I had made an escalated offer for 71.5 crores, they sell the debt for, my lord, initially, my lord, there's a Swiss challenge. It is at 68 crores. Then they sell the debt at, my lord, 70.54 crores. Now, my lord, the question, my lord, before your lordship, therefore, is, my lord, a bank, my lord, being a state authority, my lord, when it is, my lord, saying that I am going to discharge my entire indebtedness, either by sale of the security or by the transfer of the debt, whether it can, my lord, today refuse, my lord, against all the, my lord, settled principles of law, which says ultimately the bank receives the makes the maximum recovery. Well, whether, my lord, it can proceed to, my lord, say that I shall assign my debt with the underlying security at a price much lower than the offered price for the security itself.
Now, the appellant is the borrower or a appellant was a
Well, the
participant in the auction bid?
Well, I am before your lordship, my lord. I am the, my lord, auction participant. My lord, I'm not participant in the auction. I am, my lord, the individual who had come forward and made an offer by private treaty, which was under consideration. And, my lord, I had increased my
much
offer.
before this
Yes.
exercise.
Yes. Now, my lord, that is the question. Now, my lord, with the greatest respect, my lord, the learned, my lord, single judge has, my lord, really said that, my lord, when you are talking about sale of the underlying security, well, that is a completely different subject matter than, my lord, the sale of the asset. But, my lord, at the end of the day, if we, my lord, look at the things pragmatically, the bank is, my lord.
But what is the right, vested right the appellant has got?
No.
Now, if he is a borrower or he is a participant or he, if there is an offer like the asset reconstruction company and there is a counter offer, the writ petitioner is a third party.
Well, the writ petitioner, my lord, here, my lord, if your lordship looks at it from this perspective, my lord, under the statute, my lord, there is, my lord, an opportunity given, my lord, to enter into a sale agreement on a private treaty. Now, my lord, my lord, make that offer. They should have said, very well, you have not participated in the auction, I am rejecting your offer outright. But, my lord, they take my offer under consideration. They consider my offer. They proceed to, my lord, negotiate with me. I proceed to, my lord, enhance my offers from time to time before, my lord, the sale of the assignment of the debt, my lord, to the third party. And, my lord, that is how, my lord, my right, my lord, ultimately surfaces. I have a right to participate in the asset which you now sell to another person through the device of, my lord, transferring the debt itself.
But the problem is how a writ court can question the financial prudence or
No.
their due diligence of the,
No, my lord,
either
here,
the lending bank.
no, my lord, it is not a question of, my lord, financial prudence. My lord, the financial prudence, my lord, here, kindly consider only one thing. I would have appreciated it's a matter of, my lord, resolution or, my lord, restructuring. My lord, there the matter of financial prudence comes in. My lord, here what your lordships are considering, now, my lord, is the bank, my lord, keeping its scope for recovery alive in any mode or manner? No. The bank, my lord, when it is assigning the debt, it is assigning the debt in its entirety with all underlying securities. When it is transferring the asset, it is transferring the asset, my lord, keeping alive the right to, my lord, recover from, my lord, other modes. Now, my lord, here what the bank does is, my lord, the bank transfers the entire debt with all the underlying securities for, my lord, 70.54 crores. And, my lord, I had offered, my lord, to purchase the asset.
Alone for 71 plus.
Yes. So, my lord, here the question of commercial prudence will not come in at all. And, my lord, commercial prudence then, my lord, can't be, my lord, an ipse dixit of the bank. It has to be accompanied by some semblance of reason or, my lord, some probity. My lord, that is the question. And, my lord, here, so far as the matter is concerned, the learned judge, with the greatest of respect, has, my lord, approached the matter, my lord, rather, my lord, I would say, my lord, pedantically, my lord, by, my lord, saying that these are two separate, my lord, parts of the same whole. So, my lord, here, if I may show your lordship how, my lord, the matter proceeded, my lord, very importantly now, my lord, since then, my lord, my learned friends, my lord, which I think, my lord, is Mr. Mukherjee's client, has approached the Debt Recovery Tribunal, questioning the same decision. That is the decision to assign.
My lord, we can cut all this short, my lord. But your lordships put a query. My lord, I am a borrower. My lord, I was the guarantor as well as the borrower. Now, my lord, as per, my lord, the auction, my lord, there were two simultaneous proceedings happening. My lord, one was, my lord, an outright sale. Another, my lord, was for assignment of the debt. My lord, quotations were asked for both at the same time. Now, my lord, the terms of the auction, my lord, notice, my lord, required, my lord, whatever bid was given, my lord, to be open, my lord, for 30 days. Now, my lord, there was only one bidder. That's, my lord, Mr. Bose's client. My lord, if there was one bid, there had to be a Swiss auction. Now, my lord, Swiss auction, my lord, there has to be, my lord, more than two. Because, my lord, one goes off against another with that as the reserve price. My lord, be that as it may, that had to be done within 1 week. My lord, it appears there was no other bidder who came in. But, my lord, there were private negotiations and 68 crores, my lord, went up to, my lord, 70, my lord, 70.54 crores.
71.75 crores.
70.54 crores, my lord, is what it went up to. And my lord, the date, my lord, which was the outer limit, my lord, was 20th of March 2024 for, my lord, the bid to be kept open. From, my lord, 29th January 2024, my lord, the guarantor who has the skin in the game, my lord, who has given a personal guarantee, whose lands are also mortgaged, apart from, my lord, the company's land which had been mortgaged, my lord, had, my lord, started with 68 crores and up to 2nd March 2024 had gone up to 72.75 crores, which was much more. My lord, that was not considered. One line, my lord, rejection. We cannot accept your offer. We have assigned in favor of CFM. That's, my lord, Mr. Bose's client, who is, my lord, an asset reconstruction company. My lord, we went, my lord, to, my lord, the debt recovery tribunal, and we are enjoying an interim order. My lord, I must tell your lordship that interim order was passed on, my lord, the 3rd of July, 2024. My lord, I have. My lord, I prepared a compilation of all documents. My lord, which, my lord, at page, my lord, my lord, page 40. My lord, page 403 and page 405 of my.
Right. But I don't dispute the fact that there is an interim order passed by the debt recovery tribunal.
My lord, kindly have a look at that, my lord. My lord, I'm handing up another copy. My lord, this problem happens. My lord, I'm on soft copy. This is hard copy.
Respondent bank is directed not to take any coercive steps against the subject property until the hearing of the sale.
That's pending, my lord. They filed an affidavit.
But then, what is your role in this matter?
My lord, I am, my
Do you
lord.
not have a better interest than a person who has made an offer up
My lord,
to
higher. My lord, higher than, my lord.
No, my
higher
lord,
than
my
your
lord,
offer?
today, my lord, my contention is this, my lord. If, my lord, my learned friend's higher offer is considered, naturally I go out.
But the
My offer was
is written for
71.75.
the- You intervene in the proceedings which are pending before the debt
But, my
recovery.
lord, what is happening in the meantime is, my
In
lord,
all probabilities, your intervention will be
my
rejected.
lord, kindly see, my lord, kindly see one
My
thing, my lord.
lord, I'll tell your lordship what is
My lord,
happening.
only one inter, my lord.
Or probably you have been set up.
Absolutely, is a complete alter ego of the
Let us proceed on the premise that
principal borrower.
No, my lord,
My lord, your lordship will kindly hear me.
One second, sir. Now the list which is pending before the tribunal is with regard to the auction or bid, whatever it is.
Yes.
Admittedly, you are not a participant.
No, I'm not.
Probably there was some private negotiations out there.
Yes.
There, everything is left open, and you cannot question the decision of the bank. Say, suppose they assign the entire debt, underlying security, etc. It may be a more profitable, proposition for the bank than to sell the asset and hold on to the debt alone. What to do with the debt? How to go behind the borrower or the guarantor to recover? So once and for all, they commercial decision they take, financial decision they take, they assign the entire debt. So here, the private respondent has got an interest in the property because his lands are mortgaged, company lands are mortgaged, personal guarantees running. So probably you can join bandwagon with him.
Well, I can.
May I also indicate one, my lord, very important fact.
My lord, before Mr. Mukherjee points this out, my lord, as the asset reconstruction company to whom the debt has been assigned, my lord, allow me to point out one important fact. 22 failed auctions. Not one, 22 failed auctions. So, my lord, the right of the principal borrower is the right of redemption. My lord, under the judgment of Bijnor in the Supreme Court, once, my lord, a sale notice is published, my lord, his right of redemption comes to an end for all times to come. So, my lord, today, his offer of 72 crores or 100 crores is irrelevant. Now, my lord, what is after 22 failed auctions, and the last auction, well, the notice of the last auction was published as late as in January 2024. Even then, he does not participate. Then, when he,
So when was this private treaty between the bank?
no,
and
I'll tell you, my lord, that is in February.
February.
After the January public auction, he does not participate in the public auction, but makes a private offer. My lord, by then, my lord, the notice had already been published for assignment of debt, not one debt. My lord, it was a notice for assignment of 15 separate debts of different, my lord, financial, different corporate persons. So his was, my lord, the present principal borrower's account was one of the 15 accounts which was being sought to be assigned. So, my lord, that assignment process is in exercise of Section 5 of the Securitization Act, as your lordship is well aware. So that's a statutory right of the bank to transfer the financial asset with the underlying security. And that is exactly what has been done. Transparent process. And that is what, my lord, the learned single judge has come to a specific conclusion.
What is the finding of the single judge on his locus standi?
My lord, kindly have a look at the locus. He said that he has absolutely no locus. I raised the point of locus.
Rightly so.
My lord, kindly
It
take
is a
the...
clear,
He's occasionally right, my lord.
but it's a clear collusive litigation.
No, my lord,
My
may
lord-
I tell your lordship what has happened? My lord, I'm not shying away from the fact that, my lord,
So your right is fully protected.
yes, kindly, my lord, provide for that, my lord, that.
My lord,
That is,
won't
we
be
are not
affected by
going
this.
to say.
My lord, what
anything
is happening?
My lord,
No, just 1 minute. My lord, now that the bank has spoken, my lord, CFM has spoken.
yes.
My lord, may I now tell your lordships, my lord, this company is run by two brothers. My lord, one brother, my lord, has gone in with, my lord, the asset reconstruction.
Well, I don't need
That is
anybody. I have purchased it by paying good money. I have paid 70.54 crores.
Company wanted, my lord, to take steps to pay, raised an objection saying there are only two directors, two shareholders. I'm opposing, which resulted in, my lord, the brother, which is me, my lord, who I represent, my lord, saying, okay, I'm the one who's given a personal guarantee. I will offer this payment rather than from the company.
So well, that's an action under 241, 242 before the
The phrase, my
Companies
lord,
Act.
my lord, about a dhua tulsi pata, my lord. My lord, my learned friend's client is not a dhua tulsi pata either.
No,
my lord.
probably
My lord,
your brother may be behind them, but your client is clearly with them, or they are with
My
your.
lord, I accept.
My
But
lord,
I have
how
as a
does it, my lord, with the
guarantor-
greatest
But,
respect, make a
it is,
difference?
having not participated in the auction, you don't have any locus.
Well, I would have appreciated that they had, my lord, said that I will
No,
not
let
even
them-
entertain
let them
your
sort
offer.
out that issue. If you are, it is always well open to your client also to seek for intervention in the proceedings.
Well, the difficulty, I'll tell your lordship what the difficulty is today. Now, my lord, my learned friend as the assignee of, my lord, the bank has gone. The bank had, my lord, filed a section, my lord, 7 application before the NCLT. That was in the year 2022. Now, my lord, in that, my lord, the bank has no surviving interest. Now, my lord, bank has assigned its debt. Bank is now, my lord, on the one hand proceeding for recovery because it has, my lord, attempted to sell the underlying security by, my lord, private auction or, my lord, by, my lord, a public auction. Now, my lord, once the bank, my lord, attempts recovery,
22 failed auctions. You should
no,
see.
my lord, I'm, my lord, on a different issue.
auction, how much of expenditure? That expenditure is ultimately going to be loaded on to the outstanding.
Well,
Anybody participated in the sale, even the borrower as well as guarantor. When the sale was taking place, they all
Let them fight it out, sir.
there is much more than meets the eye. When
Only
he
one
is
thing.
proceeding,
Well,
my lord,
what
he
is
is not
happening-
even giving access to the property.
No,
He
my lord,
cannot take
What
possession.
is happening is,
You have to get this order vacated.
well,
No,
well, without
I
getting
tell
the
you,
order
lordship, my lord,
vacated,
this
well,
order,
only one thing, well, without getting the order of the DRT vacated, my learned friends have gone to the NCLT, filed an application seeking to be substituted in place of the bank in the Section 7 application. And, my lord, so far as that is concerned, they want to then pursue that matter. My lord, once that happens, then the security comes under, my lord, the protection or the aegis of the NCLT or the resolution professional. Then, my lord, the DRT order, my lord, becomes, my lord,
So that issue will, they will raise before DRT.
My lord, may I put it this way? My lord, as long as DRT order remains, there cannot be a resolution plan because this is an order, my lord, well before the commencement of CIRT. In fact, it's not yet been commenced, it's just been filed. My lord, unless an admission happens, there cannot be, my lord, a commencement of CIRT. So, my lord, that point will certainly take, my lord, before, my lord, the, my lord,
No,
adjudicating.
at this juncture, it may not be very prudent for your client to ride along with
No, I don't want to, my lord. I'm, my lord, squarely, my lord, saying, my lord, that this order protects me. My lord, whatever order your lordships pass, my lord, this order should not, this is not under challenge by anybody.
Which order?
My lord, the DRT order.
DRT order, we are
Yes,
not going to
I'm
say.
happy with that.
This intra-court appeal by the writ petitioner is directed against the order dated 22/5/2024 in WPA 12929 of 2024. The appellant writ petitioner challenged a request for bid for sale of non-performing assets to Asset Reconstruction Company dated January 19, 2024 and the consequential action initiated by the Union Bank of India. The learned single bench has, by the impugned order, dismissed the writ petition. Aggrieved by the same, the present appeal has been preferred. We have elaborately heard the learned Mr. So-and-so, the Jishnu Shah, learned senior advocate so-and-so, and everybody. After hearing the learned advocates for the parties, we are in full agreement with the view taken by the learned single bench. It may not be necessary for us to dwell into all the issues which have been dealt with by the learned single bench, which in our considered view is in a very detailed fashion, but suffice to note a few factors, more particularly the issue relating to the locus standi of the appellant writ petitioner. The learned single bench noted that on 22 occasions, the bank attempted to transfer the assets and they had failed. The writ petitioner appellant did not choose to participate in any of those, including the last of such auction / bid, which was notified in January 2024. Therefore, the learned single bench was right in its observation that the appellant, having not participated in the bid / auction notified by the respondent bank, cannot claim a premium on the strength of a private treaty offer, that too after the conclusion of the auction sale and the invitation for bids to acquire the NPA accounts. The Mr. S. N. Mukherjee, learned senior advocate appearing for the private respondent, submitted that the private respondent is the borrower / guarantor, and the assets of the company, personal assets, as well as personal guarantee of the private respondent had been given, and the private respondent has moved the debt recovery tribunal on the ground that their offer was much higher than the amount which was being offered by the Asset Reconstruction Company to take over the debt, not only the debt as well as the underlying security. And there is an interim order passed by the learned debt recovery tribunal. In this writ petition, we are not here to adjudicate the rights of the private respondent qua the Asset Reconstruction Company. It is up to the parties to agitate their claims before in the pending proceedings before the learned debt recovery tribunal.
Okay.
Thus, we are of the clear view that the learned single bench was fully right in not entertaining the writ petition nor granting the relief sought for. Thus, we find no grounds to.
My lord, may I just one indulgence? My lord, what your lordship has recorded, Mr. Mukherjee's submission, but kindly record my submission. I dispute this fact. My lord, the stay has been granted not on the basis of assignment to me. My lord, the stay has been granted because what was under challenge was the sale notice. Nothing more than that.
All right. After Mr. Mukherjee's
The secured asset sale was under challenge.
learned senior advocate appearing for the Asset Reconstruction Company submitted that the interim order granted by the learned debt recovery tribunal
Was much prior to the assignment. Yes, but that was in July.
Does not relate to
2024,
the assignment.
before that.
My lord,
Assignment
in
is 6
respect
months
of a sale notice. So the
No,
jurisdiction,
it doesn't relate to the assignment.
yes, does not
that-
relate to the assignment.
That's enough. Thank you.
Doesn't relate to the assignment.
Raise that issue there.
No, but the question is that this will be interpreted in a different way before the debt recovery tribunal.
We have a look.
No. And here, what transpired in court makes things apparent. Same advocate instructing Mr. Sahan,
Yes,
same
yes.
advocate. No, it's on the lighter vein. No, there's no. Next.
Great. Serial number 7.
Yes, 7, my lord, I appear on behalf of the appellate.
But I appear
Mr.
for
Bhattacharya is
WBCD
appearing on
lordship.
behalf of the appellate.
We can't adjourn, sir.
No, my lord,
Why is
I'm praying for release, my lord. Mr. Bhattacharya is appearing. Can you lord seize the impugned order?
Oh.
Lord, my instruction, my lord, connection has already been given to wife. Husband doesn't want the wife to get connection.
Sir, please come.
Instruction, non-instruction. I am wrong.
Personal ground, then the matter stands released from the list of this. It was be placed before the Honorable Chief Justice for passing decision.
What happened now?
Next.
Serial number 8, were disposed of
No. It will go before some other.
or released?
My lord, I'm being
Headquarters.
led by learned senior counsel, Mr. Kaushik Gupta. He is traveling today. On the last occasion when this was listed, your lordship had orally directed to be this matter to be listed after 2 weeks. So I think that is the reason for the confusion. It has come up today.
No, we have said list this appeal on 12th February.
Yes, my lord. But on that date, this was orally your lordship had directed. I was also there.
They
It
have
seems.
noted it down. Now the book fair is over.
It is over. On Sunday, it is over. But Mr. Gupta had mentioned on the day
he
before that
mentioned
there are larger questions of substantive.
Can we do one thing? We leave the question open. Because as on date, we leave that question open whether at all a writ petition would be maintainable against the guild, whether a direction mandamus can be issued against the guild, on the ground that the fair is already over. It is open to your organization to.
My lord, I'm just praying for a short accommodation. My lord, any day other than this.
This will be an academic exercise, no, for this year. Unless, no, probably if this appeal is pending, the next year they will cite this appeal and they will say, no, matter is sub judice, we cannot consider. Instead, we make this issue open. On the next occasion, you can take a registration or something else and convince the guild that.
Once my learned friend has finished,
He's finished.
Submission. My lord, there are the petitioner before my lord today, appellant before my lord today is Association for Protection of Democratic Rights. APDR. Now, my lord, it is first of all, my most respectful submission is that the guild does not come under the purview of a state. Guild is an independent body organizing a book fair. Now, it is their private fair. It is for them to choose whom they want to permit and whom they don't want to permit. Now, my lord, the rules for participation is decided in the minutes of the meeting of the guild. Now, this year, my lord, the entry was open till 30th of October 2024. Prior to the opening of the entry, the guild members had a meeting on 1st of August 24. There it was specifically decided that no organization will be allotted stall or table. The magazine or the book publisher will be given a stall or table. Now, my lord, these rules can be changed from year to year because it is absolutely the purview of the guild. Now, my lord, the appellant is the organization, which is APDR. Now, my lord, they have a publication in the name of Odhikar, which is a monthly Bengali organ of right movements, APDR. Now, my lord, that publication was allotted a stall this year.
No.
They had got a stall, my lord. The two applications are here, my lord.
My lord.
In that stall itself, you can.
My lord, this question fell from your lordship on the previous occasion as well, and this was it was clarified by the learned counsel that.
See, this Adhikar, a monthly Bengali organ of rights movement, APDR.
My lord, this is another. So APDR. So there is a splinter organization, splinter group. That is that. My understanding is, my instructions are that group, the splinter group, got a stall under the name of their publication. It has nothing to do with my application. And on all previous occasions till last year's book fair, the application had been in the
Adjournment
name
is
of
sought for by
APDR
learned
itself.
advocate for the appellant. We find no urgency in the matter since the book fair in question is already over. The learned advocate appearing for the respondent guild, which organizes the book fair, submitted that a monthly Bengali organ of the appellant rights movement under the name and style Adhikar, ADHIKAR, had applied for allotment and they have been allotted a stall measuring 9 into 9 square meter pursuant to the application given by them on 22/10/2024. Further, it is submitted that as per the decision taken by the guild, which is in the form of the rules for allotment, a publishing house will be entitled to put up a stall and not an organization. Since the learned advocate for the appellant would like to address this court on the larger issue, the appeal is kept pending. Listed after 3 months.
Grateful, my lord.
Serial number 9. Lord, I am for the appellant, my lord. Lord, my affidavit of service, only difficulties, my lord, all the respondents have been served. Only of, my lord, the office of the government pleader, my lord, that is, my lord, not so. My lord, otherwise, all the respondents, my lord, the magistrates, the DM, my lord, everyone is served. They have also received the copy, my lord, the police authorities, everyone. My lord, the difficulties, my lord, an order was passed on 12th of December 2024, my lord, in the residuary bench, my lord. The difficulties, my lord, I received a copy of the writ petition on 16th of December. And as such, my lord, a construction which is made, my lord, upon plan being sanctioned and every requisites, my lord, paid, that is, my lord, held to be, my lord, unauthorized. Now, my lord, the police authorities are visiting my premise upon a direction of this honorable court, my lord. They are, my lord, trying to stop me, whereas, my lord, every document I have.
No, the direction is Deputy Superintendent of Police, Superintendent so and so would personally visit the area complained of, wherein a civil court has been pleased to pass a direction.
Yes.
Thereafter, take appropriate step, thereby respecting and obeying the order of civil court. In case of any delinquency is found from the end of so and so, superior officer will take appropriate steps.
Yes.
Now,
my lord.
you are the plaintiff in the suit.
I am, my lord, the defendant in the suit.
Defendant. There is an injunction operating against you.
No, not anymore. Page 58, my lord, is my the information slip, my lord. Injunction has, my lord, already lapsed. That is gone. After that, my lord, a sanction plan was obtained by me.
So you produce it before him, then obviously it
My lord,
can't
my
be
lord,
an unauthorized.
this order, my lord, still operates.
No.
My lord, as of today.
Why you didn't appear in the writ petition?
My lord, that I have, my lord, my lord, I have, my lord, say, shown. Order was passed, my lord, on 12th of December.
Yes.
My lord, kindly comes to page number, my lord, 55. I received a copy of the writ petition on 16th of December.
Page 55.
Now, this track report I have annexed, my lord, from the copy I received after the writ petition was already, my lord, decided. The copy of the writ application, my lord, was served upon me.
We can do one thing. We can direct the Deputy Superintendent of Police and the or additional so and so to look into your documents as well.
And my lord, decide the case, my lord, accordingly. Grateful. That was
this intra-court appeal.
Yes.
By what was your rank in the writ petition? Your clients?
My lord.
You are the 8th respondent in the writ petition.
Private respondent, only private respondent.
This intra-court appeal by the 8th respondent
No,
in WPA 29232 of 2024 is directed against the order dated December 12, 2024. The learned advocate for the appellant submitted that the writ petition was disposed of by the impugned order dated December 12, 2024. However, the notice of the writ petition was delivered on the appellant / 8th respondent only on 16/12/2024. It is submitted that the order of injunction passed by the civil court had expired, and the appellant has been granted a sanctioned plan for the
by the Panchayat authorities.
Huh?
By the Panchayat authorities.
By the has been granted. Extend. But suppose the injunction had been extended, what will happen?
Injunction is already, my lord, gone. That is the reason, my lord, I am before your lordship. Had, my lord, the injunction been there, no sanction plan would have been, my lord, no plan would have been sanctioned.
Serve the writ petitioner.
Yes. Everyone is served. Everyone is served, my lord. But the affidavit of service I'll just produce, my lord. Everyone is served.
When they have received.
Served on, my lord, 31st of January 2025. They have received it.
The learned advocate, you have not served upon the learned advocate.
Advocate, my lord, have not served. Since, my lord, the appeal was, my lord, served on the party itself, my lord.
Served upon the learned advocate for the writ petitioner.
It is better.
I'll do that.
Ramji Munsi.
Lordship, my lord, directs in the order, my lord. I'll serve a copy.
Then strike out that order. The learned advocate for the appellant has to file the affidavit of service, which is taken on record. However, none appears for the respondents. The learned advocate for the appellant is directed to serve Mr. Ramji Munsi, who appeared for the respondent writ petitioner, and also on Mr. Swapan Banerjee, learned additional government pleader. List the matter on Monday.
My lord, grateful.
In fact, if you had filed an application for recalling, the judge would have recalled the order.
Your lordship, my lord, can decide the issue from here itself, my lord, since.
Let us see.
My lord.
Serial number 10.
I am appealing for the appellant. My lords will recall it is an appeal from an order dismissing the writ petition on ground of lack of territorial jurisdiction.
Yes, we remember.
My lord, the subject matter of challenge in the writ petition, before that, my lord, the writ petitioner is a consumer of coal. It consumes NLW coal. The full form is non-linked washery coal. That means it is not linked to washery. It cannot be washed in washery. Washing is a process. When a coal is put through washing, the ash content of the coal decreases. As soon as the ash content decreases, the quality of coal improves and the price also improves, my lord. We have been purchasing washery recovery coal, we have been purchasing NLW coal for many years. Suddenly, in the year 2008, a charge was levied on us called washery recovery charges from one of the subsidiaries of Coal India Limited, that is BCCL, Bharat Coking Coal, my lord. I filed a writ petition saying this levy, I filed a writ petition in which both Coal India and BCCL were made respondents. My cause of action was that this levy of washery recovery charges is in violation of the policy of Coal India Limited. Coal India Limited has framed a policy that this coal is not suitable for washing and no washery recovery charges can be levied. The subsidiary company, in violation of that policy, cannot levy this charge, my lord.
Now, affidavits were exchanged in the writ petition.
Yes, my lord. My lord had wanted to know last time whether any affidavit was filed on merits. My lord, they filed an affidavit, initial affidavit, which was given when the writ petition was moved. There was a direction for filing of affidavit. All parties filed affidavit in opposition. We filed reply. Thereafter, my lord, BCCL has filed 3 more supplementary affidavits on merits, my lord. Also,
My lord,
in the main affidavit, also they have filed. My lord had inquired something last time whether they have filed anything on merits. In the main affidavit, they have taken grounds on merit. After the main affidavit, after reply, whenever the writ petition would come up for hearing, they filed another supplementary affidavit, another and 3 supplementary affidavits on merits.
But the learned single bench has decided only
without entering into the
merit, my lord.
It will be clear.
My lord, may I place my case, my lord? My lord, my first submission is Coal India Limited is the parent body and BCCL is a wholly owned subsidiary, my lord. CIL is the apex body in the matter of formation of policy, and the policy framed by CIL is binding on BCCL. But CIL is also under an obligation to implement its policy on its subsidiaries, my lord. For this, my lord, may I just place some of the provisions of the article?
First, let us see the prayer and the writ petition.
My lord. The prayers in my writ petition, my lord.
Page 178.
Yes. Prayer in the writ petition, my lord, page 82 of volume 1.
No, not 82.
My lord.
Page 178 of the stay petition of Can 1 of 2023.
My lord, paper books have been filed. My lord, last hearing, my lords had the paper book. In the last hearing, my lords were having the paper book.
There is no paper book.
My lords had made notes in the marking the paper book.
The paper book is here.
Want to see the prayer? Tell you see there.
My lord, it's after paragraph 72, my lord, the prayer. My lord. Prayer A writ in the nature of declaration do issue declaring levy of washery recovery charges on NLW coal and wireless message dated 13 June as arbitrary, illegal and bad. So both the levy for which CIL is also responsible and in particular a wireless message by which this levy was introduced. So I've challenged both the decision as well as the wireless. My lord will kindly take prayer B. A writ in the nature of mandamus do issue calling upon the respondents and each one of them to forthwith revoke the decision, revoke, rescind, recall and set aside the decision to levy of washery recovery charges on NLW coal and the wireless.
And who issued the wireless message?
Wireless was issued by BCCL in violation of the policy of CIL, and CIL has also is party to such illegality by permitting it to levy such levy, my lord. Then my lord will kindly see prayer D. A writ in the nature of mandamus do issue restraining the respondents and each one of them from levying washery recovery charges. Where are the paper books, Shubhika?
This BCCL,
my lord,
registered offices in Calcutta.
No, my lord, the registered office of BCCL is in Jharkhand,
Anba.
but one of its offices is in.
But the issue is
My lord.
to allow prayer A to declare that the levy of washery charges is
My lord.
illegal. Essentially, we'll have to consider whether the decision of BCCL was contrary to the policy framed by the parent body, namely Coal India Limited.
My lord.
And admittedly, BCCL is not situated within the territorial jurisdiction.
Registered office is not, but one of the offices.
Administrative officers may be there.
Yes, and CIL is
One
entire.
more prayer is to refund the charges which were collected. So the order of refund, assuming a writ is allowed and it is declared, one of the prayers is for refund that needs to be allowed. That will be issuing a direction upon a respondent who's outside the jurisdiction of the school.
My lord, if my humble submission is, if the subject matter of challenge is implementation of a policy, my lord, whatever the consequential release, my lord, various matters, my lord, CIL is a parent company for all the coal companies all over the India. My lord, Coal India Limited is parent company for all its subsidiaries. There are several subsidiaries.
But then it is the action of BCCL which is being questioned, because the policy of Coal India Limited remains untouched. Their registered office is in Delhi, is it?
No, CIL is in West Bengal, my lord.
West Bengal.
They have registered office here.
So if suppose you seek for a direction, CIL is issued a direction that henceforth this washery charges should not be levied. Despite that, if BCCL levies it, probably you can seek for a direction to implement the directive of CIL upon the subsidiaries or the
My lords, in several matters when policy has been issued by CIL, which has repercussion on all the subsidiaries all over India, my lord, writ petitions have been filed in Calcutta. My lord,
the wireless message also emanates from Jharkhand.
I'm not, my lord, wireless message is from, but my lord, I'm obliged, my lords had last time asked me to consider kusum ingots and come. My lord, in this matter, whether washery recovery charges can be levied on non-linked washery coal, the most important part of cause of action is coming from Coal India Limited, my lord. It is the
No, the cause of action for the writ petition is based on the wireless message issued by BCCL.
My lord.
My lord,
Because
there
the
is-
policy of Coal India remains untouched.
my lord.
My lord.
If there is some variation, etc., then there will be a problem. That remains untouched. These people have issued a direction saying that you have to pay for this. This, according to you, could not be issued. It is for them to justify how they can issue it or not. So essentially, substantial part of the cause of action for the litigation arose outside the jurisdiction of this court. Nonetheless, when you argue that matter before the jurisdictional high court, you can always refer to the policy and say what will be the binding effect of the policy. Because the answering respondent is outside the jurisdiction. That is the only issue.
My lord, may I try to impress upon my lords? My lord, had the policy of Coal India not been there today, I would have had to argue on merits as to why the levy of washery recovery charge on a coal which is not capable of being washed bad on merits. But today I have a policy of Coal India Limited which says it cannot be done. My humble submission is this policy of Coal India Limited is integral part of my cause of action as has been recognized in Kusum ingots, my lord. And that policy of Coal India has direct nexus and relevance to the list in this writ petition, my lord.
Let us see how the learned judge has concluded
My lord.
against you.
My lord, the learned judge has said,
Sir, volume 2 is there, page 670.
my lord can look at it from the memo of appeal if my lord
No,
pleases.
it's better. Memo of appeal so bulky.
Yeah, both.
Oh, only. All right, I have flagged here. $670.
Last day, my lord, I was marking from the memo of appeal.
694 on-
694.
694 onwards, my lord.
It's okay, I'll manage.
And where is the decision on
My
this
lord, the
point?
decision starts from paragraph 7 or paragraph 5. The learned judge says, I have heard the learned counsels for the party, written notes have been filed. Paragraph 7 at bottom of page 700.
700, 701.
It appears that the petitioner have primarily challenged a wireless message dated 13th June 2018 issued by BCCL imposing washery recovery charges on NLW coking coal. The petitioner alleged that under the respective fuel supply agreements, they received NLW coal from BCCL. The same was not linked to washery. However, the respondent contended that these points ought to be taken up before the High Court Jharkhand. 8. In this context, it may be germane to cull out the admitted facts as under all the 91 FSAs were signed executed in Dhanbad. Stamp papers used to belong to state of Jharkhand. Address of BCCL was given as Dhanbad. CIL, the parent company, and BCCL is not a party to the FSA. Clause 91.3, the governing law stipulated that the courts at Dhanbad shall be exclusive jurisdiction in all matters. There was a representation made by Coal India as well, to Coal India as well. Clause 91.3 of the FSA provided that the courts of Dhanbad would have exclusive jurisdiction in matters under the agreement, not matter of policy, my lord. First, there is no High Court at Dhanbad. Secondly, this is the line, my lord, no policy decision of Coal India, albeit having effect on the business of FSA, was purportedly taken within the jurisdiction of Dhanbad. In fact, a policy decision like that is also not in the subject matter of FSA. Clause 91.3 is thus not capable of contracting. My lord, this was on the exclusive jurisdiction clause. My lord, I'm sorry, the relevant paragraph is 10, my lord. My lord, may I place it?
Yes.
There is paragraph 10 at page 702.
702.
However, there is no averment or prayer in the writ petition that petitioner wanted to quash the alleged policy decision of CIL. My lord, we did not want to quash. We wanted implementation, my lord. It is settled law that under Article 226 of the Constitution of in India confers jurisdiction on a High Court to act in two different modes. One of Clause 1 of Article 226 allows the court to act if the respondent authority had seat office within its territory, while Clause 2 permits High Court to entertain a writ petition if part of cause of action takes place in the jurisdiction. Even the decision in Kalyan Banerjee recognizes that Article 226.1 and 226.2 are independent grounds for territorial jurisdiction. One has to see quite independently whether the courts can entertain the instant petition either in terms of Clause 1 or Clause 2 of Article 226. Paragraph 13. First, the policy decision of CIL does not seem to have direct bearing on the main prayer in the writ petition. My lord, I'm saying it has a direct bearing on the prayer. My lord, here the policy of CIL is the main part of my cause of action, my lord. And CIL has its registered office also within the jurisdiction. May I read the second line of paragraph 13? Nor was CIL a party to the FSA. Only by giving a notice or representation to CIL, such entity cannot be dragged into the present list. But this was not the only ground on which I had invoked jurisdiction, that I have written representations to CIL, so that is the only ground on which I am bringing in CIL.
No, CIL has not acted on your representation. If you have wanted a direction upon CIL, saying that CIL should impose its policy on BCCL, then part of the prayer would have been against CIL. You want to keep the CIL notification intact and then seek for a declaration that the demand of washery charges is illegal or contrary to the policy. So essentially, it's outside. And apart from that, the learned judge notes that in terms of clause 9.
My lord, I will try to satisfy my lord on that also. My lord, Coal India is the parent, BCCL is the subsidiary. Agreement is entered into between the writ petitioner and the subsidiary. So as far as short supply, bad quality supply, that is governed by the fuel supply agreement between the subsidiary and the writ petitioner. If they do not supply the quantity which they are under the fuel supply agreement, under a duty to supply, or if they supply me lesser quantity which they are bound to supply under the fuel supply agreement, that is a matter which will be governed by the fuel supply agreement between BCCL and my clients. But if it is a matter of policy which is framed by Coal India Limited, matter of policy framed by Coal India Limited is not covered by the fuel supply agreement, my lord. So that is, and the fuel supply and those writ petitions which were filed in Jharkhand High Court were with regard to suspension of my agreement because some of them had not lifted the quantity they were obliged to lift under. It was not a matter of policy which was subject matter of challenge in the writ petition in Jharkhand High Court, my lord. My lord, thereafter, the prayer made by the petitioner, my lord, I'm placing paragraph 13 itself. The prayer made by the petitioners in this writ petition could very well be there in litigation between the petitioners and BCCL, even without involving CIL. Therefore, regardless of whether there is a residuary power made in the petition or not, the cause of action alleged in the writ petition does not directly bring within its ambit the decision of CIL. My lord, CIL is, as I had submitted earlier, had the decision of CIL not been there, then I would be out of this court, my lord, because then I would have to go to Jharkhand. But since it is a matter of policy of CIL, my lord, CIL every month is issuing grade notification and price notification. CIL does not sell coal directly. CIL sells coal through its subsidiaries. These price notifications and grade notifications, my lord, are issued by CIL for its subsidiaries. These price notification, grade notification, first, they do not provide for washery recovery charges in the price list. They give the basic price and they say that no washery recovery charges can be levied. My humble submission is the washery recovery charges which are being levied by BCCL is in violation of the price notification and grade notification of CIL issued within the jurisdiction of CIL. My lord, may I just place the few clauses, my lord? And only one paragraph is left from the judgment of the learned trial court. That CIL is not party to FSA. Obviously, my lord, CIL is not party to FSA because that is with regard to the quantity which was to be supplied supplied by BCCL to the writ petitioner. CIL can at best be treated as a pro forma respondent herein, merely because CIL also has an address within the jurisdiction of this court. It would not be just and proper for this court to entertain the litigation, as the writ petitioners do not have a subsisting jural relationship with CIL. This is more so when several other writ petitions connected issues have already been entertained by the High Court at Jharkhand, and this court in Kala Kok has refused to entertain the petition on ground of lack of jurisdiction. There was a similar writ petition, my lord, in Calcutta High Court, which was having the name Kala Kok, which was dismissed by the learned trial court on the ground of lack of territorial jurisdiction. In that matter, no appeal was taken up. During the hearing before the learned single judge in this matter, the learned single judge repeatedly inquired whether there is any appeal. We informed that the client could not afford an appeal. They did not carry the matter in appeal. My lord, I had appeared in that matter also. So, therefore, I find no reason to depart from the view taken by this court in Kala Kok. So my learned judge was more of the view that since there is already a judgment of a concurrent bench of a single judge, I cannot take a contrary view. That view taken in Kala Kok, but that judgment in Kala Kok of the learned single judge is not binding. My humble submission before my lords. My lords can decide the matter, my lord, without being bound by whatever has been laid down therein, my lord. My lord, may I, CIL is my first submission is CIL is the apex body in formation of policy. The policy which is framed by CIL is binding on its subsidiaries.
Page 90.
My lord.
You referred to page 90.
Yes, I'm grateful, my lord.
Now, before that, can we see the agreement between the appellant and
yes,
BCCL?
The agreement is in volume 2. Starts at page 271. 270 actually, my lord. My lords will find that coal supply agreement between Bharat Coking Coal and Asha. Then page 271, my lords will kindly take the recital agreement between Bharat Coking Coal within bracket subsidiary company, the seller, and Akash Kol, one of the petitioners, my lord. Kindly come to page 272, definition section, clause 1E. Base price shall mean in relation to a declared grade of coal produced by the seller, the pithead price notified from time to time by CIL or seller, as the case may be. The control of CIL is throughout in this agreement. BCCL cannot at today say, I will fix price, I will declare grades of coal as I like. Shall mean its landed price intimated by CIL or seller, as the case may be. My lords will kindly take clause G. Coal means non-coking coal as well as coking coal produced domestically and categorized into different classes, grades, and sizes as per notification order issued for such purpose by Government of India / Coal India Limited / seller, and shall therefore and shall, where the context so requires, include imported coal. Clause H. CIL means Coal India Limited, the holding company of the seller. Clause I. Declared grade. Declared grade means the particular grades of coal mined from any seam or section of a seam in the seller's colliery from which coal is produced and supplied under this agreement as declared by CIL. My lords will thereafter kindly come to (282), my lord. Clause 10. Price of coal. Clause 10.1. As the delivered price of coal for coal delivered hereunder shall be the sum of the base price and sizing charges, transportation charges up to delivery point, rapid loading charges, statutory charges, levies, such and such. The components of as delivered price of coal shall be determined on the basis of rates, criteria duly notified by CIL. Clause 10.1. Seller statutory authority from time to time as is applicable to the purchaser and in force for the time being. 10.2. In the event of revision by Coal India Limited or the seller of any component of the as delivered price, my lord, so Coal India has the authority to fix the price, and in the definition section, I have also placed that they will declare the grades. In clause 1E is the price, and clause 1I is the Coal India's power to declare grades. And clause 10 is the price of coal that is also to be declared by Coal India Limited, my lord. And my lord, it's not relevant. 283, I just want, my humble endeavor is to show the deep and pervasive control which Coal India is having over the affairs of CIL, my lord. 10.4, the price of imported coal may be decided and declared by Coal India Limited. Though not relevant, my lord, I'm just trying to show the role of coal. No. Where is the forum selection clause? My lord, the forum selection clause, which was rejected by the trial court, their argument before the trial court was there's a forum selection clause, and in the clause, the forum selected is Court of Dhanbad. So another ground why you should be out of this court, apart from territorial jurisdiction, is the forum selection clause. That ground has been held in my favor, my lord, and there is no appeal. So the learned judge has held that you cannot contract out of Article 226 by selecting a clause in the agreement. If you otherwise have a right to approach a particular code under Article 226, if you satisfy under clause 1 of Article 226 or Clause 2, if you satisfy, you cannot contract of your right under the articles of the Constitution by providing something to the contrary.
But essentially,
my lord.
this is a variation in the price. See,
My lord.
if you see the definition of as delivered price of coal,
Yes, my lord.
1D,
Yes.
shall have the meaning ascribed to in its clause 10.1. 10.1, as you said, read, coal delivered hereunder shall be the sum of the base price, sizing charges, transportation charges up to the delivery point, rapid loading, so on, so other charges. The components of as delivered price of coal shall be determined on the basis of the rates criteria duly notified by CIL, seller or statutory authority from time to time. So therefore, CIL has issued a notification.
My lord, may I show that note straight away from here, my lord? My lord will kindly take the price notification issued by Coal India Limited, which is in volume 1, page 88. There are two notifications. One is grade notification. The other one is price notification for the various grades which are declared.
Yes,
Page 88. My lord, at page 88, this is page 88, my lord, is the grade notification of Coal India Limited. Various grades of coal are notified here. Kindly take the third grade of coal notified at page 88. It says non-NLW coking coal, the third entry. This coal is not used in metallurgical industries because of higher ash content. This coal is not acceptable for washing in washery. This coal is used for power utilities and non-core sector consumers. My lord will kindly thereafter take
page
the
90.
Grateful, my lord, the price notification. The first paragraph, it says that the last line that of first paragraph, with effect from 1st January 2000, CIL was free to fix the paragraph thereafter. Pursuant to the above, CIL fixes the price of deregulated coal from time to time, and the last such revision has been made on 15th October 2009 to be effective with effect from 16th October 2009. Grade-wise basic price of coal at pithead, excluding statutory levies of run of mine, which is in the other page will be referred to as ROM, of long flames, such and such different grades for various subsidiaries of Coal India are listed, my lord. Thereafter, they are listing. My lords will kindly make a note of the price listed at page 91.
Yes.
Under table 2, the prices are mentioned here. This price 3750, 3140, 2740, 2020. They are, my lords will find all these prices in the price notification issued by BCCL immediately thereafter. Because whenever a revision is issued by Coal India, revision is not done by anybody, the prices of coal. It is done by Coal India for its subsidiaries. Immediately after a revision is made by Coal India, where it says for its subsidiaries, it's saying for various subsidiaries of Coal India, the subsidiaries issue a corresponding price notification, and where reference is made because of the revision done by Coal India, we are issuing this subsidiary. But a route has, this price notification is binding on the coal company subsidiaries, my lord. Only permitted exclusion is clause 12 at page 92. For undertaking special sizing or beneficiation of coal, additional charges may be negotiated between the purchaser and the producer producer may be realized over and above the pithead price. So the price which is notified at page 90 and 91, particularly page 91, is binding on BCCL, except for where BCCL is offering certain other facility like special sizing. It is not just giving the coal, but it is giving coal of a special size, segregated size. Or if it is improving the coal in certain manner, beneficiation of coal, additional charges, then that is permissible. Apart from that, no other charges can be levied by any of the subsidiaries in violation of the price notification. My lord, the coal which they are offering to us, it's neither special sizing nor beneficiation. It is not coming within the exclusion or the extra right which has been created in favor of the subsidiaries under clause 12, my lord. Now, and in any event, it has to be negotiated, my lord. That was never done, just a wireless came, we had to pay, we have no other source of coal, my lord, to take from. We are small scale industries, we have been on their promises, my lord, under linked quantity, we had set up the units, my lord. My lord, will kindly see the price notification issued by BCCL immediately after this, which is at page 170.
170.
Yes, my lord.
The above price is based on the price notification
obliged,
of
my lord.
CIL dated 15th October 2009, which you showed on page
My lord.
90 and 91. Over the page 171.
Yes, my lord.
Colliery producing coking coal linked to washeries. You have to. You wanted us to compare it with page
My lord,
90
yes, my lord. I had shown it to my lords last time, my lord. It's my duty to
with
show
page
it.
91.
Yes, my lord. If my lords compare page 91 and page 171, it is exactly the same. Page price 3750, my lords will find in the second column, first row, BCCL for 53 units VDA. Then the next, and my lord will find this price is the ROM price. For steel grade 1, there are 3 prices. One is ROM, which is the run of mine. CIL is notifying run of mine, not the other prices. Run of mine, then slack and steam. So all ROM prices is the same as that which is being notified at page 91, and CIL is notifying only run of mine prices. 3750, my lords will find at page 91 for steel grade 1. 3140, my lords will find for steel grade 2 at page ROM prices at page 171 and also at page 91. For steel washery 1, my lords will find the price ROM price 72740 at page 171 and 91, my lord. My lord, it's the same price. My lords desire that I should place each and every.
So therefore, what happens is,
My lord.
one issue is that they are acting contrary to the price notification of CIL, which according to you could not be done. But essentially what has happened is additional charges are being demanded, which according to you
they
is
cannot
not permissible in terms of CIL notification and not permissible all right, not permissible in terms of CIL notification. But essentially what happens is, it is a price difference which is being questioned now. The basis of the price difference is one issue, which is on the merits of the matter. So essentially, once a price difference is being questioned as being without jurisdiction or as being on the ground of profiteering or for certain malafide reasons, that is a different issue. But once there is a variation in price, you may have XYZ reasons challenging that. Therefore, it becomes a dispute under the agreement. If it becomes a dispute under the agreement, the procedure provided under the agreement, you need to exhaust. And how a writ court can intervene.
My lord, my humble submission is no right of mine under the agreement has been violated.
No, essentially, the test is that, see, according to them, let us say Coal India Limited has fixed for this particular category of coal at rupees 100. They were collecting 100. All of a sudden, BCCL says you have to pay 100 plus 10 as 110. So this amounts to price variation, which will be, according to you, contrary to the agreement, because the agreement refers to the price policy framed by CIL. So essentially, the relief is substantially and only against Bharat Coking Coal Limited, BCCL, and no part of the cause of action is against CIL.
My lord, I'll be at the cost of repetition, my lord. Our humble submission is that is the today to say on whether this levy is good or bad, my lord. Coal India Limited is the most important party, my lord.
No, Coal India Limited can be a party before the Jharkhand High Court also, because he can be a pro forma party just to place facts. Even here also, the learned single bench says, you showed one more document,
my lord,
where this BCCL 550 or something. Where is that?
550. My lord,
Please put it to that 505.
Kindly come to page 60.
16, my lord.
60, your writ petition paragraph
My lord.
37.
6. Paragraph 37. My lord.
PIL has also issued a subsequent notification in tune with the notification of 13th of June 2008 of the BCCL. Page 60, paragraph 37.
The date of the notification.
15th October 2009.
My lord, there was a price notification issued by CIL.
We were challenging that the BCCL did not have the authority to levy washery charges.
My lord.
In view of the fact that the CIL did not issue such.
My lord.
Now, your own averment is that after BCCL imposed that, CIL has also in tune of that in supersession of earlier notification has also levied.
No, my lord. My lord.
That is the statement in paragraph 37.
My lord, 37 says, my lord, on 15th October 2009, the respondent issued, Coal India Limited issued a notification in supersession of its earlier notification dated 12th December 2007, notifying prices of various classes and grades of coal. The said notification contemplated
levy of washery charges. So in tune with that, CIL has also modified, issued a subsequent notification.
And that you get it at page 174.
Yeah, what is it? Well, 13 June. No, my lord, that is no, it's a mistake, my lord. I'll show the primary documents. It's BCCL issued. My lord, I'll show the primary documents. My lord, the notification dated 15th October 2009 is referred to in paragraph 37. My lords will find that that is page 90, which I placed.
We're at page 156.
My lord, page 156. My lord. My lord, 156
Where is P11?
P11. P11 is 16th October. Is at page 170.
170.
My lord, that's a mistake in the writing the page number in the 170. My lords will find page 170, P11. The date is 16th October. So our pleading there is on, where's page para 37? 15th October is the notification of Coal India Limited. In implementation, purportedly in implementation, CIL issued notice, BCCL issued notice on 16th October 2009, which is page 70. So we had requested my lords to consider page 90, which is 15th October, with page 170, which is 16th October. In 15th October, there is no mention of washery recovery charges, which is the notification of Coal India Limited. And in 16th October 2009, which is page 170, there is mention of washery recovery charges in violation of the price notification of Coal India Limited. My lord, these I stand corrected by my learned junior. These page numbers are, but it should be page numbers of the writ petition, my lord. When in the paragraph that mistake in the page number is because of that. Don't be smart, huh? Just tell me what it is. My lord, after this notification of 16th October 2009, which was at page 70, my lord, I had not shown one part of it. May I place it, my lord? Then that document, page 170, I had shown at 171, prices are same as Coal India Limited.
Page 174, clause N.
My lord, I'm deeply obliged. N.
So therefore, essentially it's a price variation, which you are questioning. The cause for variation may be different. It may be X, Y, Z reasons. But essentially, you have been paying your as per notification at page number 90, you are required to pay only 15th October is first. After this, please find enclosed in the device. Your price list is based on the price notification circulated by Coal India Limited.
Give the list of dates.
That is what she says. 15th October is at page number 9.
The list of dates for the judges.
Provide for this.
My lord, I had prepared one-page list of data if it's of any assistance to my lords. Take a copy of the side. My lord,
But this Coal India price notification,
my lord,
I think some pages are missing.
my lord, at
Page 90 to 92, you see page 92 bottom annexure. Because BCCL refers to 15th October 1990.
Yes, my
I'm
lord.
sorry, 2009. And at page 174, they say for NLW coal at the rate of 505 rupees per ton, in reference to the wireless message so and so. So they could not have got something else, but some pages are missing in this
My lord,
CIL notification.
the date is at the bottom of page 91.
Yes, we saw that.
My lord.
General remarks, price notification for so and so. Then over the page, the revised pitted, etc. Then notes. Then at below clause 14, it says annexure. What is this annexure? Page 91 also, there is one annexure, table 2 annexure, table 3 annexure, table 4 annexure, table 5. And specifically in page 170, BCCL says, please find enclosed here with the revised list of coal, which is effective from 24 hours 15/10/2009, that is 00 hours up to 16th October. The above price list is based on the price notification of CIL dated 15th October.
My lord.
They could not have. There is something missing in this. But ultimately, the bottom line is you are challenging a price variation. We are not concerned about the reasons for the variation. If it is challenge to the price variation, you are before the wrong court. That's it. You keep CIL intact, and now that Vinita has been designated as senior advocate, Jharkhand High Court will also have the benefit of.
Don't give any cognizance. The last observation of my lord, don't give any cognizance.
Don't give?
Don't give any cognizance. Who said senior advocate? Nobody up till now.
It is on the way, sir.
Give cognizance.
No, there are only 2 days available in a week. Friday evening, Saturday evening. Every weekend is booked.
No intimation even to me.
Coming, sir. Probably it's a destination celebration. It will be a destination celebration, not within Kolkata. So it is essentially, madam. Please.
My lord,
That's why a good thing is the learned judge didn't enter into the merits of the matter.
my lord, it was decided only on the territorial jurisdiction, issue of territorial jurisdiction. My lord, we have prepared a 2-page note. My lord, if I can place it. My lord, one more thing, my lord, we were saying we had to argue before the learned judges that the right of a petitioner to approach under Article 226 under Clause 1 and Clause 2 of Article 226. One is where the respondent is located under Clause 1, and under 2, where part of cause of action has arisen. They are independent rights. So CIL has a policy not to recover washery recovery charges.
No, it
CIL
doesn't appear so. It doesn't appear so because we can't doubt the veracity of the statement made by BCCL in page 170. In clear terms, they say the above price list is based on the price notification of number so and so dated 15th October, which is on page 90 and 91. And that is why they have added this condition at page 174, clause N.
My lord, they have not said that what I have annexed is incomplete document, my lord. I don't have instruction.
Oh, yeah, that's what.
My lord, that is not their stand. They are the authors of the document, my lord. There is no case, there's no list that this is not an authentic or complete document, my lord. Neither CIL, who is the author of the document, nor BCCL, who has implemented the document.
See, it is so, madam. Please see
my lord,
page 174 bottom. Please, P, clause P, small p. Enclosed copy of annexure Roman 8 and Roman 9 of price notification. What is that annexure?
My lord, that is at starting from page 175. That is
list of collieries producing coke linked to washeries.
Yes.
Admittedly, your colliery is also one among the list.
No, this is the entire list which is being issued by coal in Bharat Coking Coal, my lord. I might be getting coal from one of them. There are other consumers as well, my lord. At page, starting from page 176, 75, my lord.
What is this No.
My lord, that is the list of dates, my lord, 1 page. My lord, this is the 2.5 page note which we have tried to prepare, my lord. If my lords permit, I may read it, or my lords prefer.
No, we'll go through.
My lord.
On what ground the fuel supply agreement was cancelled, which was challenged before JARC?
My lord, as far as I am not there, but it was suspension under the fuel supply agreement for not having lifted the agreed quantity of coal, my lord.
Probably on account of not agreeing to pay the washery recovery charges.
No, my lord, it is, I can, where have we dealt with in the opposition?
Now, what is stand of BCCL? BCCL says that you have got the independent authority to fix the price.
Yes, my lord, that is what they have said. I've
My
listed
lord,
the paragraphs.
my lord, if my lord comes to first file the fuel supply agreement first, my lord.
Paragraph 7 of the note, my lord.
My lord, before my lord entering into the merit, my lord, since the question as to the maintainability.
That alone we are deciding.
My lord, and the learned single judge, my lord, did not enter the merits of the matter.
No, that we have seen.
My lord, if my lord pleases, I could enter into the merit.
No. You don't enter into the merit.
My lord, your lordship has just now observed, there is also a coming, if the federal jurisdiction is, my lord is with Mrs. Mehra, then my lord, he is asking for violation of the condition of agreement. Whether my lord without evidence in read court, even read court can go into.
No, that we will not go into. That is up to them.
If,
But what is the
possibly if she can file there, he can ask this question again. But if your lordship entered into the merits of the case,
No, we will not do that.
considered
No, what is the stand of BCCL? You tell in 2 words or 2 sentences.
My lord, fuel supply agreement had been entered into
No
with
dispute.
91 petitioners, 91 writ petitioners. The fuel supply agreement, my lord, is it with respect to supplying of coal, my lord. My lord, that is coking coal, my lord. Now, my lord, subsequently, then the fuel supply agreement, there is revisable clause. There is revisable clause because, my lord, the thing is that the coking component of the coal may be increased. The metallurgical value of the coal has to be increased by washing the coal component, my lord. In that respect, the metallurgical value of the coal will be increased, my lord. And that is there in the fuel supply agreement, my lord. And that is also known to them, my lord. And there are within these writ petitioners, my lord, there are in the impugned judgment also, there are 6-7 writ petitioners who had filed separate writ petitions before the Jharkhand High Court, my lord, on the same cause of action, my lord. My lord,
What happened to those writ petitions?
my lord, that
That you don't know.
that I
All
don't know, my lord. But my lord, the thing is that the value of the washery recovery charges is in the fuel supply agreement, my lord, and BCCL issued that notification for implementation of that washery recovery charges, my lord. Now, my lord, challenging that implementation of the notification issued from Dhanbad, my lord, they came in by filing a writ petition here. On the ground, my lord, the CIL, my lord, is, my lord, my respectful submission is that CIL has 7 subsidiaries, my lord. Other than BCCL, there is Eastern Coalfields Limited, there is Western Coalfield, Northeastern Coalfield, spreaded into different states of India, my lord. Now, had that head office being, if that be so, that entire policy of the several subsidiary belongs to the CIL. Now, had that been so, my lord, then every writ petition in Mumbai, in Madras, then they will come to the Kolkata, my lord. This honorable court had the jurisdiction simply because CIL is the head office of, and they, in their writ application also, that is the paragraph 64, my lord, in their writ application. Volume 1, my lord. The only content, the only argument is that, my lord, only awardment, my lord, rather I say. My lord, that is the paragraph number 64 at page 80 of the paper book 1, my lord, volume 1. That is the only awardment, my lord. That the honorable court has jurisdiction in the matter, as that the respondent BCCL is a wholly owned subsidiary and under the control of the respondent CIL. Respondent CIL is the apex body and the decision-making authority regarding the matter with us domain, including including any contradictions of the business by its subsidiaries, and as such, decisions are binding on all subsidiaries, including respondent BCCL. That is their only thing. My lord, they even, my lord, if my lord come to the representation, their representation also, page 143, my lord, come, my lord, 143, volume 1, my lord, 143, my lord. My lord, several representations has been made, my lord. Kindly come to page 143, my lord. The representation has been made to the ministry, my lord. My lord, no representation at all been made to the CIL, my lord. Now, my lord, in the representation, my lord, in the first paragraph, my lord, the coal company BCCL issued wireless message, white wireless message number such and such dated 13 June 2008 to all the areas to realize the washery recovery charges from its non-court sector and court sector consumers with effect from such and such. It is surprising that the coal company has decided to charge washery recovery charges for NLW non-linked, although the said coal is not at all linked with the washery. Thus, the question of charging washery recovery charges does not and should not arise, my lord. Now, my lord, come to page 144, my lord. The step of coal company implementing the above price will definitely increase the production cost of the hard coke, leading to the coal. My lord, it is their case, my lord. That is the coal company issued that notification. My lord, that they challenge the notification issued by the coal company itself. It is their representation that the coal company issued notification in a illegal manner. My lord, had it been the coal company issued the notification in an illegal manner, that has been issued. My lord, the administrative office of the coal company is outside the state, my lord. Now, my lord, in the writ, my lord, my respectful submission, my lord, there is a prayer of certiorari, my lord, for transmitting all the papers and documents, my lord. If honorable court invokes their jurisdiction even of certiorari, my lord, then, my lord, from the outside state, all the papers, my lord, that is, and moreover, my lord, it is they also, my lord, gone to the Jharkhand High Court, my lord.
No, that we have
My
not
lord,
yet. Now show the coal supply, fuel supply agreement.
yes, my lord. Volume 2, my lord.
Volume 2.
Page 270, my lord, to 270 onwards. Now, my lord, first page 270, my lord, that is between Bharat Coking Coal Limited, that is one of the petitioner, my lord, Akash Coke. Now, my lord, first page, that is in Jharkhand, my lord. The seller, the word seller is very important here, my lord, in the fuel supply agreement. The word seller is very important. Now, my lord, in the first page, my lord, BCCL is the seller, my lord, and the purchaser. Now, my lord, if come to the, say, my lord, base price. Now, base price at page 272. My lord, what has been stated, my lord, shall mean in relation to a declared grade of coal produced by seller, that is the BCCL. The pitch price notified from time to time by CIL, my lord, or seller. That is not end seller. In everywhere, if my lord, if my lord, I've gone to the entire fuel supply agreement, this fuel supply agreement is with the seller. My lord, CIL has no role to play with this, in this fuel supply agreement, and not even a party to this fuel supply agreement. Entire thing, my lord, base price, the washery recovery, the additional price, and everything, my lord. Declared grade, my lord, if my lord comes to the declared grade,
Yes.
my lord, if my lord come to the declared grade as to the onto the grade in terms to the seller's collieries. Everything, my lord, everything, my lord, with respect to the seller and the purchaser.
No, you said there is some clause which permits
the recovery. Oh, my lord, yes. My lord, the last page. My lord, page 324, my lord. 324 of the FSA, my lord. Before that, my lord. My lord, kindly come to 10.2, my lord, first, page 282.
Page 320.
No, lord, page 282 first. 282 first, my lord. Clause 10.2, my lord.
That we are saying.
Yes. 10.2, my lord.
Not plus 10.1.
At 10.1.
One is in
My
not
lord,
plus.
10.1 I will place, my lord.
No, everywhere it's an admitted fact. It is CIL or seller or statutory authority.
And my lord, the purchaser shall be liable to pay the revised as delivered price of coal from time to time from the date of the revised rates or criteria becomes or has become effective, my lord.
As well as other charges.
Other charges, my lord. That is 10.1, my lord. The or other charges. That's other charges is there, my lord.
Then what about 324?
And 324, my lord, that is the revision criteria, my lord. That is in determination of the volatile matter and the moisture shall be carried out on the coal samples as per the procedure laid down in the Indian standard specification number such and such. Determination of the gross calorific value shall be carried out in accordance with the procedure laid down or by any subsequent revision thereof.
I think it's better that you agitate it before Jata. Please come. This intra-court appeal.
Only one fact my lord wanted to know.
Cause of action paragraph, my lord has seen. Paragraph 64.
My lord, when the
Cause of action under 26.2 to 26.2 is within the jurisdiction of the Lord's court.
That we'll decide.
That's the only point.
My lord, I would be beseeching my lord to look at the reply also because interim order, when no interim order was passed, when it was moved, they raised a point of jurisdiction. So it said it would be decided after affidavits. So they took a point of jurisdiction in opposition. I have dealt with it in my reply, my lord.
Page?
My lord, in the reply, my lord, page 342, my lord, paragraph 6, I have stated. Volume 2. Reply to the opposition of BCCL at page 342, 43, 46, and it's open. At 342 at bottom.
342 bottom.
Yes, my lord. Then page 343, my lord. It's binding.
Sequence obligation.
Yes. And then in the middle, further such illegal levy of charge, CIL is enjoying the ill-gotten fruits of its subsidiary. And my lord, this is, and then again, 346 at the top, CIL by allowing and consenting to levy of charge by BCCL is party to such illegal and arbitrary action.
Okay, we'll consider. Please come.
And the other writ petition, which was filed in Jharkhand High Court, my lord wanted to know what is the subject matter that we stated at page 561, volume 3. It was with regard to termination of FSA of some of the writ petitions, my lord.
That is because of clause 11.
No, my lord, it is not pension, my lord. What was the reason? It just says that.
Besides the point.
My lord.
My lord, may I please one point, my lord. My lord, that had been raised before the my lord honorable single judge, my lord. My lord, kindly come to the my lord the cost title of the writ application, my lord. My lord, my lord, the writ petition has been filed by Industries and Commerce. My lord, that is an association, my lord. Now, my lord, from the writ, there is no FSA, no fuel supply agreement with writ petitioner number 1 and BCCL, my lord. 2291 is the FSA, my lord. My lord, this writ petitioner, my lord, in the affidavit section, my lord, it has been stated that all these 91 writ petitioners, my lord, given power of attorney to the to Mr. One name was there to the power of attorney holder below. Now the power of attorney also was not given to the Industries and Commerce, that is the association, my lord. My lord, no legal right has been vested to the association, my lord. My respectful submission, my lord, to file this writ application, my lord. My lord, there is, but that is my respectful submission, my lord.
Single bench should be here. 70. 670 will be in which? Volume 3. Volume 4. This interpret appeal by the writ petitioners in WPA 30381 of 2014 is directed against the judgment dated 16/12/2022, by which the writ petition was dismissed on the ground that this court does not have territorial jurisdiction. As could be seen from the impugned order, the learned writ court did not go into the merits of the matter, but chose to decide the maintainability of the writ petition before the High Court at Calcutta, as a preliminary objection was raised regarding its maintainability by the respondents. In this appeal, we also adopt the same course and restrict our consideration as to whether the learned single bench was right in dismissing the writ petition on the ground that the High Court at Calcutta has no territorial jurisdiction over the subject matter. We have elaborately heard so and so. At the outset, firstly, we shall refer to the relevant paragraphs of the writ petition, relevant paragraph of the pleadings in the writ petition concerning the writ petition, as to how the writ petitioners seek to maintain this writ petition, maintain the writ petition before the High Court at Calcutta. It has been stated in paragraph 64 of the writ petition that this court has jurisdiction in the matter in as much as the respondent, Bharat Coking Coal Limited, within bracket BCCL, is a wholly owned subsidiary and under the control of CIL, Coal India Limited, within bracket CIL, full stop. The CIL is the apex body and the decision-making authority regarding matters with its domain, including matters regarding mode and manner of conduct of business by its subsidiaries, and such decisions are binding on all its subsidiaries, including BCCL. The CIL has a seat within the jurisdiction of this court. It is not in dispute that CIL has its registered office in the state of West Bengal, namely at Kolkata. The prayer sought for in the writ petition was to issue a writ of declaration to declare the levy of washery recovery charges on NLW coking coal and the wireless message dated 13th June 2008. The petitioner also sought for issuance of a writ of mandamus to revoke / rescind / recall / cancel and set aside the decision to levy washery recovery charge on NLW coking coal and the wireless message dated 13th June 2008. Further, the petitioner sought for issuance of a writ of mandamus to restrain the respondents from giving effect to the decision to levy washery recovery charges on NLW coking coal and the wireless message dated 13th June 2008. There is also a prayer for refund of the amounts collected from the writ petitioners on account of washery recovery charges on NLW coking coal on and from June 2008. Though it has not been specifically mentioned as to who has issued the wireless message, dated 13th June 2008 in the prayer column in the petition. It is an admitted and undisputed fact that such wireless message was issued by BCCL and not CIL. The case of the petitioner itself is that BCCL has no jurisdiction to levy washery charges on this particular category of coal, as the price notification issued by CIL dated 15/10/2008 does not contemplate levy of such washery charges. In this regard, the learned senior advocate appearing for the appellant petitioner has elaborately taken us through the notification issued by CIL, price notification issued by CIL dated 15th October 2009, and submitted that if a comparison is made with the notification issued by BCCL dated 16th October 2009, will clearly demonstrate that there is a variation and such price variation could not have been done. The question of whether CIL's directives are wholly binding on its subsidiary, namely BCCL, is an issue which touches upon the merits of the matter, which the learned single bench did not go into, and we also do not propose to go into. However, we are required to take note of the submission of the learned advocate appearing for BCCL, who has referred to certain clauses in the fuel supply agreement within bracket FSA, and submitted that the agreement is between two parties who are defined as seller and purchaser. And as could be seen from the sample agreement which has been annexed in the paper book at page 271, the agreement was admittedly entered into at Jharkhand, in the state of Jharkhand, as the stamp paper was also purchased in the state of Jharkhand, and the seller is BCCL and the purchaser is one of the writ petitioner, which is a company having registered office in Kolkata. Further, the learned advocate has referred to the definition of base price as defined in clause 1 within bracket E, declared grade as defined in clause 1 within bracket small I, and other conditions in the agreement to
Has delivered price of coal.
So on so, and clause 1 within bracket D, which defines as delivered price of coal to mean as prescribed in clause 10.1. It is submitted by the learned advocate appearing for the BCCL that a reading of clause 10.1 would clearly show that the as delivered price of the coal shall be determined on the basis of the rates/criteria duly notified by CIL or the seller or the statutory authority from time to time. In this regard, the subclauses under clause 1, namely clause 10.1 and 10.2, has also been referred to. It is true that the agreement has used the expression or in several places. Therefore, the question would be as to whether the BCCL is independent, has an independent right with regard to price fixation or price variation in terms of the terms and conditions of the agreement, is also an issue which will be touching upon the merits of the matter, which we do not propose to tread into. Essentially, the issue relates to price variation. It is the contention of the appellant writ petitioner that the price variation cannot be done, or in other words, the washery recovery charges cannot be levied because the the subsidiary, namely BCCL, is bound over by the terms and conditions and the price notification issued by CIL. Therefore, it is evidently clear that what is being challenged by the writ petitioners is a variation in the price of the coal, and the issue to be decided on merits would be whether BCCL was empowered to do so. Therefore, essentially, the matter revolves around the rights of parties pursuant to the fuel supply agreement entered into between the companies who are petitioners 2 to 91 and the seller, namely BCCL. Therefore, as rightly observed by the learned single bench, CIL is at best to be termed as a pro forma party. The contention of the appellant that BCCL, by levying washery recovery charges on NLW coal, has violated the grade/price notification of CIL is an issue arising out of an agreement between the parties. Therefore, if a challenge is made before the appropriate forum having jurisdiction over BCCL, this issue could be decided, but not by this court, solely because Coal India Limited has its registered office in the state of West Bengal within the territorial jurisdiction of the High Court at Calcutta. Though we are tempted to make certain observations on the merits of the matter, we refrain from doing so as it would impinge upon the rights of the writ petitioner. One more issue which was pointed out by the learned advocate for BCCL is that the first appellant/first writ petitioner cannot be stated to be an aggrieved party, since the first appellant writ petitioner is an association and there is no agreement between the association and the seller/BCCL. This issue also requires to be agitated before the appropriate forum having jurisdiction over the subject matter, and the same is left open. The learned single bench had also noted the admitted facts, namely all 91 fuel supply agreements were signed and executed at Dhanbad, semicolon. Stamp papers used belong to the state of Jharkhand, semicolon. The address and registered office of BCCL was at Dhanbad, and CIL was not a party to the agreement entered between the seller/BCCL and the writ petitioners 2 to 91. Further, the learned single bench noted that in terms of the clauses in the agreement, the governing law stipulates that the courts at Dhanbad shall have exclusive jurisdiction in all matters under the agreement. Yes. On this issue, the learned single bench had held in favor of the writ petitioner, as against which no appeal has been preferred by the respondents, and therefore the same attains finality. Furthermore, the learned single bench noted that CIL was not a party to the fuel supply agreement, and as no specific prayer has been made challenging the policy decision of CIL, the CIL can at best be treated as a pro forma respondent. And merely because CIL has an address within the jurisdiction of this court, it would not be just and proper for this court to entertain the litigation, as the writ petitioners do not have a subsisting jural relationship with CIL. That apart, the learned single bench noted that the other writ petitions on connected issues have already been entertained by the High Court at Jharkhand, and one writ petition filed by one Kala Kok was dismissed on the ground of lack of jurisdiction. The learned senior advocate appearing for the appellant would contend that the writ petitions which were filed in the High Court at Jharkhand related to orders passed by BCCL suspending the fuel supply agreement and not on the issue which has been canvassed by the appellants in this appeal. Be that as it may, we are satisfied that no part of the cause of action where the relief sought for by the writ petitioner in the by the appellants in the writ petition arises within the jurisdiction of this court to entertain the prayer sought for. For the above reasons, we find no grounds to interfere with the order passed by the learned single bench. We make it clear that the merits of the matter have not been gone into, and even assuming there are certain observations in the preceding paragraphs that should not be taken to be expressing an opinion on the merits of the matter, it will be well open to the appellant to canvass all grounds in the event they are advised to approach the jurisdictional forum. Yes, ma'am.
My lord, the time spent in pursuing this litigation, my lord.
The appellant seeks to pursue other remedies. Appellant seeks to pursue other remedies before the forum having jurisdiction. The appellants will be entitled to plead that the time which is spent before this court, that is during the pendency of the writ petition and the pendency of this appeal, may be excluded. Excluded for the purpose of computation of limitation. And if such prayer is made, the said appropriate forum/court will consider it in accordance with.
Grateful, my lord.
Don't use the word proof. So, and the appellants are at liberty to raise all issues before the said appropriate forum having jurisdiction. That lady,
Lordship may remember, Lordship entrusted me the responsibility to look after her case as a pro bono lawyer, Lordship. Lordship, according to the, I have filed her case during the month of July. After that, she was not getting a date. That's why she has come, and we have talked here to the officers of your court, Lordship, and with their interference, a date was given on 24th of January this year, Lordship. But on that day, unfortunately, I was suffering from high fever. That's why I asked her to go and get a date. And the next date has been given on 18th of March this year, Lordship. So I have, but somehow it is her, she's thinking that she will not get remedy from there. I made her understand all the due process of law, that how she will get her remedy with, this is not the proper forum, but she
pending before which court?
DLRO, Lordship, Krishnanagar DLRO, Lordship. And Lordship, she now wants to describe her state before your Lordship. That's why
What
she has.
can we do now? There's nothing pending before us.
2010 থেকে স্যার আমার ঘুরেছে, my lord, আমাকে ঘুরেছে, আমাকে দিচ্ছে না, সবাই পাচ্ছে। মৃত ব্যক্তি পেয়েছে 2000 সালে মৃত হয়েছে তার সে পেয়েছে 13 সালে যখন আমি পাট্টার আবেদন করি আমাকে দেবে না আমাকে দেবে না এটা
ELLRO has given a date on.
কিভাবে অন্যায় করছে আমাকে
You listen to, you tell her, she is correctly advising her. She is correctly advising her. You believe, you keep,
আমাকে দেবে না
you shake your head means you go out. You go elsewhere. We are requested the learned advocate to assist you because she was appearing in another matter. You are refusing to even listen. Nuisance.
না আমি এটা দেখাবো
Percy, may I be permitted to mention in tomorrow's list,
Hmm.
there is a matter that is below threshold limit. It may be taken up out of turn, but we are not informed. But one thing, my lord, it is a refund matter, my lord. So one line may be incorporated. We are not falling under the exceptions because in case of customs or central excise, there is a circular and threshold limit 2 crores. But there is an exception is there is a refund, but it is in the question of law and recurring in nature. Both are not being satisfied.
We will list it on Friday under the caption to be mentioned.
Yes, my lord. This
I think
line
we would have signed the order. So let it
because
come.
we are not being informed at all, my lord, because most probably your lordship directed. But
We thought 3 matters are there, we'll finish it off. The Stapan Banja said
my
yes.
name was in the earlier. Anyone can inform. We can appear even virtually.
Friday it will come.
To be mentioned.
One matter for non-prosecution.
My lords, passed a detailed order in the matter of Harsh Polyfabric, the appeal split order, my lords. My lords, there are certain corrections that we are requesting, my lords, because this classification issue. So, my lords, we have made those corrections in the order itself.
You sure?
For my lords too.
But who will appear for
I have served it to the other side, my lords.
small typographical mistakes, etc. Anjan, we can show it in days list.
Harsh.
Several mistakes. Or what we have to say is because in the order which has been signed and uploaded, there are several mistakes. Mistakes have been carried out, and the revised order be signed and uploaded. The matter has been shown under the days list by the caption to be mentioned. It is pointed out by the learned advocate for the appellants that there are several typographical and clerical mistakes in the order which needs to be rectified. Since the mistakes are in several places, the order which has been signed and uploaded shall be removed, and the corrected order which is and the order which is corrected and signed today shall be uploaded. This order shall form part of the order. No.
Oblige, my lords.
May I seek your lordship's leave to mention, lordship, two matters, lordship, where the name has been inadvertently included as Mr. Dhuduria. Mr. Pratyush appeared with me, your lordship, but sir, I had given the corrected slip, but inadvertently, I think Mr. Dhuduria's name has appeared for the SSC, lordship.
Okay.
On the other day, lordship, he had appeared.
This correction also you please make up. In the order dates also. Instead of the name Mr. Pratyush appearing for the respondent, it should be mentioned as Mr. P. Junjunwal. Yes.
Audience side daily list item number 1. Item number 1.
This is below tax effect.
Yes. Instruction.
You got written instructions?
My lord, I have written instructions.
No, we have it, lordship. Written instructions.
Okay. This appeal has been filed by the Commissioner of Customs, Port, Calcutta, against an order passed by the tribunal. The department has given written instructions that the tax effect involved in this appeal is below the threshold limit. If that be so, the department cannot pursue the appeal further. Accordingly, the appeal stands disposed of on the ground of low tax effect Consequently, the substantial questions of law suggested are left open. The written instruction given by the department to the learned standing counsel is kept on record. On record.
I'm appearing for the applicant, Lord. It's a delay of 76 days. I'm appearing with Mr. Oh, I'm right. No, delay by the control 68, madam.
Your throat is gone.
Yes, ma'am.
There's a delay of so and so days in filing the appeal. As the explanation offered is convincing, the delay in filing the appeal is condoned.
Item number 3.
You are appellant, huh?
94 days. Respondent served.
Respondents have 94 days, my lord. Only thing I will pray, my lord, it's exactly similar to the earlier order that my lord passed in that Imami matter. Because this order has been based completely on the Imami order passed by the tribunal. My lord, and now there's an execution application in this before the tribunal. Tribunal has said that since there is no stay in those applications, although appeal has been admitted, since there is no specific stay, therefore within 7 days you comply with the order. Now the difference in between the two is here the importer has not filed the appeal. In that case, both of us had filed an appeal. So in that case, my lord had passed an order where, based on the Commissioner Appeals directions, those directions were to be followed, and the result would be abide by the appeal.
In that, in the other matter, they agreed to abide by the order passed by the commissioner.
Yes, yes. Here
for destruction.
Yes.
For incineration.
Yes.
Here, what has happened?
My lord, here they have not filed an appeal. There, the Commissioner Appeals had passed an order for.
Now, in this appeal.
In this appeal, there is a specific order that this should be re-exported.
No, what they say is page 42.
My lord.
Coming to the above option, joint re-examination afresh as given above.
My lord.
Appellant chooses to opt for re-examination.
Yes.
The decision of tribunal would be as under A.
Yes.
If the re-examination results confirms so on so.
This is exactly same to what was there in the earlier matter also.
Now, what you have not filed an appeal?
He has not filed an
My
appeal.
lords, because after this order of honorable tribunal, my lords, this tribunal order was passed on their behest only. My lords, why please come to the same tribunal's order, my lords. Para 2 and 3. I submitted that in my favor, there is honorable tribunal Ahmedabad. Identical facts, identical product in dispute. Honorable tribunal Ahmedabad has quashed those orders. But just my bad luck that before the date of my hearing, 2 days before that, Imami order came of the same Calcutta tribunal, different bench. They said we will follow the division bench of the same tribunal. Therefore, in that matter, we have decided, and it was submitted by the department only, my lords, that please follow that order. Department submission are recorded at para number 3, my lords, of the tribunal's order, that please follow Imami order. My lords, please come to that. Page number 36, my lords.
On the other hand, learned AR submitted.
That is exactly what I am saying.
Coordinate benches, so and so, so and so.
So, my lords, after this, because AR submitted do this order, my lords, we were seeking quashing of the order of the appellate authority. Or tribunal said you because, my lords, they only based on visual examination, they concluded that it is solid municipal waste that we are importing. Therefore, my lords, this honorable tribunal said, do the joint inspection in presence of some expert agency. Because department appraiser and the department officers, they are not the experts to tell on visual examination as to what is the solid municipal waste and what is not. Therefore, it's a very plausible order, my lords, by the honorable tribunal, that pollution control board.
Now, how are you aggrieved by this direction?
Yes. I am aggrieved by this direction to the effect that the hazardous waste rules as well as the OM 2010 specifies that it can only be re-exported. Now,
but one more opportunity has been given for re-examination, joint re-examination.
So again, joint and then, my lord will kindly see the tribunal first says agrees to the contention of the department, agrees to the fact
that that the importation is wrong. It is prohibited. This ought to have not. I'll show. Allow me, please, my friend. Allows me. I'm saying from what has been is there appearing before my lord in the order. Thereafter, in the Imami matter, they said, okay, you do one thing. You also go before they gave a choice. After coming to the finding that this is wrong, they give a further choice based on the 2023 OM. Now, 2023 OM couldn't have been applicable for goods that were imported in 2021. That is my appeal. That is my appeal. Apart from coming to a finding in my favor, thereafter, based on the 2023 OM, the tribunal said that you go through this process that has been given in 2023. And that was an option that was given to the importer, to which I have challenged, that this couldn't have been given. So, which is why on that basis, my lord has admitted my appeal. So, my humble submission is, my lord admits this appeal. My lord kindly gives me a stay. Because in the other matter, there was a specific appeal by the other side, by the importer, where they wanted this to be the commissioner appeals order of disintegration they wanted to follow. In this case, there is no specific order of the commissioner appeals of disintegration also. That is the only difference.
May I, my lords?
If my lord reads the whole order and
But where is the OM of 20?
My lord, will kindly see page
where it is quoted in the tribunal order, my lords.
My lord,
Doesn't refer to
page
it.
43. My lord, page 43, which is number 4.
No, page 38, Krishna tissues. They have in that judgment, the reference.
Which one am I reading?
Page 38.
Is my lord taken up Casta number 3?
Page 38 is
Casta number 3. Yes.
Page 38.
Yes.
That quoted paragraph 31.
Yes.
Within that quoted paragraph 13.
Yes.
In view of our discussion, the department in association so-and-so
Yes.
is directed to examine the goods as per the revised OM dated 10/1.
That's correct, my lord. That's correct.
Now, when was this import in Krishna tissues? Now, where is your substantial question?
My lord. Nikal.
Page 5 and 6.
इसमें अलग है इसमें अलग.
Question number D.
Yes, my lord.
Page 27, question D.
Yes.
Yeah, how do you rely upon on what date bill of entry was filed?
2021 and 22, my lords.
Then?
My lords, this is not, my lords, allow me one or 2 minutes, my lords. This OM is not relevant. We never quoted in our pleadings before the Honorable Tribunal. What Tribunal has done, my lords, see, I'll just explain.
Just walk through, sir, somewhere. If municipal garbage is lying, it's a common man will be able to tell. Upon examination, they said medical waste has come in.
Medical waste, there is
you are a big blue chip company manufacturing paper, etc., and you are making our country a dumping ground.
My lord, there is a
not only
my lords, there are
used masks, my lord. Used masks are there. Milk is there. Milk containers are there. All kinds of rubbish is there.
Where is the inspection report?
My lord, will kindly see.
It should have been quoted by the commissioner or at least the original authority, adjudicating authority.
My lord, will kindly see the show cause notice, which is at page 161. Page 50, my lord, page 50. My lord will see. My lord will see from page 54 onwards and specifically comes to page 55. wherein some waste and discarded slippers, food packaging waste and plastic bottles. This is in one consignment. The same page, my lord, last paragraph. Bales, soft drink plastic bottles, rubber tube, discarded shoes, discarded 3-ply face mask, plastic grocery packet, plastic detergent box, plastic juice box have been found. My lord, next page kindly comes, page 56, another consignment. Household waste like plastic bottles, juice tetra packs, soft drink cans, discarded shoes and slippers, discarded bags, plastic detergent box, plastic hair oil box, milk packet, discarded plastic cloth hanger, discarded mobile back cover, 3-ply mask, rubber gloves, surgical gloves, discarded wire, plastic chips packets. My lord, next page is very important again. Page 57, the last paragraph. My lord will kindly see just 8 lines above the end. On detailed examination, goods found in quite dirty condition and foul smell was observed in the container. However, in most of bales,
Now, the commissioner confirmed this order.
Yes, my lord.
Where is the finding of the commissioner on this?
My lord will kindly come to page 74. Page 74, the order starts.
No, this is order in original.
This is order in original. Then, my lord, commissioner is at page. Sticker as following. This one. This.
Should be 112.
Sticker as following. Well, I will kindly come to page. What is this page number? 112.
112.
That's the last annexure, my lord. Need it,
At 116
Yes.
and 18. Now, how does the tribunal reverse this decision?
My lord will kindly come to the tribunal's decision. It follows Imami. It follows Imami's tribunal decision and says that this order will follow. My lord will kindly come back to the impugned order. My lord will. My lord will kindly see page 37. Paragraph 6.
So there is no independent adjudication.
No independent.
My lords, allow me 2-3 minutes. My lords, when we import waste paper, what we are doing is importing waste paper to convert it into duplex boards. We have consent from pollution control board also, state pollution control board also, to recycle the wastes also, because my lords, we procure these wastes from domestic as well as international sources. When we procure from international sources, my lords, there are accredited agencies which are accredited by under FTP, Foreign Trade Policy of India, Ministry of Environment. They give certificate that whenever these consignments are coming to India, you ensure that non-recyclable waste is not more than 1%, and there should not be any solid municipal waste or hazardous waste. In all my cases, my lord, we have inspection certificates from these accredited agencies. So, as on date, my lords, apart from the visual examination of the department, there is nothing, no expert opinion which is against me that what is the content, what is the percentage content of these material, what is and whether these are hazardous or not. My lords, by visual eye, we can tell something is waste or not. But whether it is hazardous or not, under the rules, that only expert can tell. Therefore, my lords,
more importantly,
the honorable,
the facts of this case were not adjudicated by the tribunal. Rather, they chose to follow Imami.
Yes,
paper.
my lord. My lords,
in Imami paper, the commissioner's order was slightly different.
Yes.
He directed destruction of the goods.
because that was a prayer by Imami, because they have some boilers, I believe.
Maybe. So therefore, that is sufficient to prima facie hold that Imami was on different set of facts. Okay, that is for prima facie. Nothing will happen to your waste. It will become what is it, more hazardous, that's all. So therefore, in that case, the commissioner said, you do incineration, and rightly so, the importer agreed to abide by the commissioner's order.
They challenged that order before tribunal. Hence, once the honorable tribunal directed a joint inspection, like in my case, they have followed. Then they said, "Ki my demurrage etc. is much more. I'm not interested in the content."
Problem is segregation. So you give some credence to the bench also, having dealt with certain matters. The segregation is the biggest issue. The pre-shipment certification will be on a container-to-container basis.
Yes.
It is based upon a declaration given by the importer or the consignee. I'm sorry,
exporter.
Consignor.
Exporter.
From whichever country it is exported, they issue a certification. It is virtually impossible to examine container by container because as many as 30, 40, 50, 100 containers will come. So sampling will be done. So once sampling is done, the packing is so very beautifully done. So even if you puncture a hole elsewhere and you pull it out, you will get only waste product. So what happens is the entire containers are taken to the yard in your factory, dumped in the open yard, and manually segregated. You ask your client.
Yes, my lord.
Manually segregated, mostly by women who are paid very low wages on a daily basis with absolute no protection.
And children
no gloves, no mask, nothing. They will be exposed to so much of danger, but on account of poverty. And what you do is you establish all these factories in the most backward area, get a lot of subsidy also. So you go unnoticed. Like 50% of the villages will be in your payroll. You'll take care of the local temple, you'll take care of the local church, you'll feed the people in the mosque.
ITC versus Noresia, there's one judgment from Madras. ITC versus Noresia.
Where is that?
Noresia doesn't. Give me that ITC versus Noresia.
It is crime against society. Even if one container contains, let us say, half ton of municipal waste, that one sample is sufficient to dump your client in the high seas. The re-export is another big problem. You will sink the entire vessel. Things have happened. You are appearing in this jurisdiction. You would have come across cases where a vessel was supposed to be scrapped. Nowhere in the world vessels are allowed to be scrapped, and the best destination is India. Even South African countries have banned scrapping of vessels because it is so much of pollution, it causes so much of hazardous waste. India is the only country in 3 places this scrapping of vessels. So what they have, these scraps, the vessels which have to be scrapped,
Particularly from paragraph 30, is actually a beautiful judgment which gives in every minute detail of how this whole thing is carried out. My lord, let's see paragraph 38, 39. दे रहा हूँ यार मैं ये देख लेने दे फिर मैं देता हूँ
are you carrying your laptop with you? Can you open the single bench judgment?
Yes, my lord.
2008 222 ELT 323.
वो तो उन्हें कैसे बात कर लैपटॉप ले आओ
Because this is SCC online, it doesn't contain the full cost title.
My lord. Oh, this one, ITC Limited versus. Hmm. My lord kindly gives me the
2008,
2008,
222, 222 ELT 323, Madras.
there are other, apart from this, there are other judgments of Bombay High Court also, which has deprecated this whole.
My lord, my only submission is that let there be an examination. Yani, what tribunal only says that let the experts examine.
We will
And
consider
they,
whether
and they have,
examination is required to be done.
my lords, only by way of visual examination, someone cannot say it's hazardous waste. My lords,
My lord,
if
the
I can't
hazardous
find,
waste rules specify that customs can do it, and in this case, each and every container has been examined by the customs department.
my lord, how do you arrive at that whether it's hazardous or not? That is the only issue, my lords. We said that there has to be an agency or expert who to say that.
No, this joint inspection or re-inspection theory itself came into the mind of the tribunal because of the 2023 notification.
2023.
Even if
Not
it
the
23
date
was
of
not there at that time.
even if it is not, my lords, even if that joint inspection is not there, my lords, as on date, what is against me? Only their visual examination, my lords. Natural justice requires that there has to be an expert who certifies whether there is any hazardous waste or not.
Expert to see whether used masks, experts to see cans, Coca-Cola cans, experts to see dirty slippers.
Those are recyclable waste, my
We
lord.
need experts to see whether
Those
these
are
the
not hazardous waste, my lords. Recyclable slippers, etc. All these are recyclable wastes.
My lord,
And their own OM says.
the hazardous waste rules once. This is which one?
2016. My lords, please come to their first OM 2010, my lords. It says,
my lord, kindly see the hazardous waste rules once. Kindly comes to
Page 66 schedules.
page 66, schedule 7. My lord has schedule 7. My lord, we kindly see. This is a list of authorities and corresponding duties. My lord, we kindly see the last, which is at page.
Yes. 6.
My lord, we'll kindly see serial number 6, which is 3 pages after that, my lord. Serial number 6. Port Authority under Indian Ports Act and Customs Authority under the Customs Act. Verify what they can do, verify the documents, inform the Ministry of Environment, analyze waste permitted for imports and exports wherever required, train officials, etc., take action against exporter or importer for violations under the Act and the Customs Act. Next page, my lord. So that has been done.
please come to page 44 of their appeal, my lords. Page 44 of their appeal, which is the first OM of 2010, which is relied upon, my lords.
44.
Page 44 of their appeal. This is the OM of 2010, which they relied upon to start case against me. My lords, para 7, clause 7.
No, OM,
The extent of
OM 10 is a secondary thing. First, the hazardous waste rules itself gives me that right. That's what I was showing, my lord.
May I read, my lord?
OM only makes it, says that this has to be sent back.
You understood your. There is a permissible limit
Of recyclable content, my lords.
So that is there under even the now the Food Safety Act, earlier Prevention of Adulteration of
Yes.
Act. I suppose what is adulterated milk. So the pH value should be so much. So even if secretly water has been added to the milk, it will not be adulterated.
Yes.
So that's the yardstick. This is correct. So
My lord.
in a container, if the percentage of what do you say,
Recyclable waste.
recyclable waste is over a threshold limit,
Yes.
that is permissible to be brought.
Yes. That is a,
But here, on facts, two authorities have concurrently mentioned that it is complete municipal garbage, municipal.
even tribunal has held that.
Solid municipal waste. No, tribunal has not held it.
Even
Tribunal has
tribunal
not
in
held.
Imami has held that, which has been followed by this tribunal.
No, my lords, it has tribunal has not held in my case. They have clearly said do a joint inspection because appraising officer cannot say whether something is hazardous or not. It's solid municipal waste, my lords. So there is
That judgment, my lord. Printer.
lords, they have written to
The
the state
judgment
pollution
that
control board
he
also, my lords.
ট্যাবটাই দাও না, ওটা দাও, ওই ল্যাপটপটা দাও, ওই ল্যাপটপটা।
Lord, if it was so.
May I hand over the. এটা তো এই অর্ডারটা। Please keep it. This is what Imam order. I'm sorry, I couldn't hand over. May I give the iPad to Justice Ghosh? अभी वो दो ऑर्डर दीजिए जो ट्राइब्यूनल ने दिया है। You have an extra copy now. कौन सा अपील? अच्छा, इमामी का ऑर्डर निकालो, वो तुम्हारे पास है नीचे।
This is the judgment. This is the judgment. This is the single bench judgment of the court issued saying
सर डाउनलोड कर
क्या
मोबाइल में आ गया
क्या क्या डाउन हाँ
जजमेंट नहीं खुल रहा
बोलते हैं दूसरा
और जो जजमेंट अभी
कोई बात नहीं इसमें आ गया ना हमको फॉरवर्ड कीजिए व्हाट्सएप में okay you sent just now
Lords, the Honorable Tribunal's order, my lords.
Yeah, please.
Is my last submission, my lords. The Tribunal's order, my lords, merely says that there has to be an independent expert examination, my lord, because dispute is between me and department, my lords, and I cannot be at the whims.
No, if you read the single bench judgment in this case, arising out of this appeal, where the appeal, CPCB took a stand that they are ready to examine. See, when do you take a second opinion? What is called a second opinion? You go to the health center here or the clinic medical unit here. You say that I am having headache, cough, cold, etc., etc. Then they give you some paracetamol. For 1.5 days, nothing happens. You keep on swallowing the pills. Then you take a second opinion. You go to a chest physician. So he has to first say whether the line of treatment adopted was right, put you on to various tests, and then come to a conclusion, no, this is this sort of infection, we need to treat you like this. So to have a different course adopted by the person giving the second opinion, he has to find out the mistake in the first opinion. So once the original authority has gone container by container, adjudicating authority or inspection, may not be a technical inspection in your presence, hazard waste management trained officers, CPCB officers are not there, etc. may have been. Nonetheless, there is a report. Unless you discredit the report, you don't have a second chance.
There is a Panchnama only, my lord. There is no report. There is only a Panchnama which records all these, that this is what we have done. And my lords, again, I am at the whims and the fancies.
Panchnama is what is seen is recorded in the Panchnama.
By that, my lords, I am merely at the.
Say, as an importer, you cannot escape.
My lords,
you cannot
then I am only at the whims and the fancies of the officer who is assessing me. Because officer says it is hazardous, it is hazardous. Officer says no hazardous, not hazardous. Even the Honorable Tribunal or any independent expert is not allowed to see the consignment. What
in this case, how many containers came? You see, in this case, ITC case, 1,000 containers.
Yes.
How many were caught? 40.
My lords, my lords,
all big players
Honorable
still.
My lords, I am a very small player. My lords, Uniglobal, I am not a very big player. My lords, frankly, and my lords.
How many containers you got?
67 containers.
What is the earlier
11.
one?
Sorry, my lords.
Who's your customs house agent?
Customs house agent.
Is he also a co-noticee?
Some Vishnu Priya Trading.
Yes, he is.
Must be.
Sorry, sir.
Yes, my lord. He is.
No, who's your custom source agent? He should have also been put on notice.
No, my lord, he has not been. In our proceeding, he has not been.
Because these fellows are all habitual.
My lords, again, my lord, the
person who does chain snatching will do only chain snatching. Person who wants to, steal, two-wheelers, he will do only that.
my lords, there has to be a test report. As my lords fell from my lord, well, there is no test report. Only a appraiser who has recorded that these are the things. Whether those are hazardous or not, my lords, let a trained expert verify. That's what tribunal says, my lord. Nothing else.
We will hear both of you at length. This appeal has been filed by the Customs Department, challenging the final order dated 24/4/2024, passed by the Customs Excise Service Tax Appellate Tribunal, East Zonal Bench, East Zonal Bench, Calcutta. The
page 30, substantion.
The impugned order is a common order passed in two cases concerning the same importer, namely Messrs. Uni Global Papers Private Limited. The learned tribunal, by the impugned order, directed re-examination of the containers, and if upon such re-examination, the examining authority holds that there is no violation of statutory provision of pollution and hazardous materials in the imported consignment, the confiscation ordered by the in the order in appeal Where is the order in appeal you just now showed?
Page 112. 112.
The last annexure, my lord.
Order in appeal.
Annexure E. Last annexure, which is at page 112.
The date is 16th February, correct?
Yes.
16th February 2020.
16th February 20.
Would be treated as set aside. The second limb of the direction is that if the re-examination result confirms the earlier conclusion arrived at by the revenue, within bracket, that the imported consignments contain municipal and consumer domestic waste, biomedical waste, etc., bracket close. In such a case, the importer / respondent would be required to re-export the offending prohibited goods. If they fail to re-export the same, the consequence would be as mentioned in subparagraph 36 of the impugned order. The importer was bound by the final decision of the re-examining authority. The revenue being agreed by the same has preferred this present appeal, raising certain substantial questions of law. We have heard so and so, senior counsel, etc. On perusal of the order passed by the learned tribunal, we find that the learned tribunal did not examine the facts of the instant case, but thought fit to follow the decision, follow the coordinate bench decision of the learned tribunal in the case of Imami Paper Mills Limited. The operative portion of the decision has been quoted in paragraph 6 of the impugned order, and accordingly, a similar direction has been issued. As against the order passed in Imami Paper Mills Limited, both the importer as well as the revenue had filed appeals before this court, and the appeals have been admitted. So far as the prayer for stay is concerned, that was found to be not required, since the importer in the said case agreed to abide by the directions issued by the First Appellate Authority, who directed that the cargo should be incinerated as per standard norms. Therefore, we are required to consider this appeal independently towards the appeal filed by the revenue as well as the importer in the case of Imami Paper Mills Limited. In our prime facie view, the question of re-examination of a cargo would arise when there is material to discredit the initial examination. On a reading of the order in original, we prima facie find that the description of the goods stuffed in the containers, 69 containers, 67 containers, did not conform to the pre-shipment certificate. On a cursory perusal, of the order in original, of the show cause notice and the order in original, we find that the examination had been conducted on several containers, and it has been found that the containers contain waste material which have been referred to as municipal waste, and that they are hazardous waste, and the same is not permissible to be imported. This the order passed by the adjudicator. So ultimately, the adjudicating authority, by order dated 23/2023, confiscated 327.09 metric tons of goods declared to be waste paper soft mix / waste paper news / waste paper ONP number 7, valued at rupees 68,33,081.17, which have been found to be waste paper not satisfying the description actually given in the declaration, and found to contain contaminants like vitrifiable organic matters, medical waste, household / domestic waste, municipal solid waste, plastic bottles, grocery bag scrap, computer printouts, bleached cup stock, plastic laminated food containers, packages, plastic lids, plastic wrappers, plastic coated cartons, foils, contaminated plastic coated paper containers, books with covers, used brown craft, etc., and were found to contravene the import policy as well as the provisions of the hazardous and other waste within bracket management and transboundary movement bracket close rules 2016, along with the office memorandum dated 11/5/2010. If a penalty was imposed under section 112 within bracket C within bracket small I, 112 within bracket small b small I, and 114 capital A of the Customs Act 1962. There was a direction to re-export the goods agreed by the same. The importer had preferred appeal before the First Appellate Authority, who re-examined the facts and concurred with the adjudicating authority. Therefore, in our primacy view, it was incumbent upon the learned tribunal to examine the factual position and also consider the case of the importer as on the grounds that may be canvassed before the learned tribunal. Thus, without going into the facts of the case, the question of discrediting the examination done by the department would not augur well. Therefore, we are of the view that the appeals should be heard, for which the appeals are required to be admitted, and accordingly they are admitted on the following substantial questions of law. Page number 26, 27, sir. A, B, C, D, and 28, E and F. G also. A, B, C, D, H. The learned senior advocate appearing for the appellant revenue contended that the importer has filed an application before the learned tribunal for execution of the order, and that the appeals which were admitted in the case of Imami paper was brought to the notice of the learned tribunal. However, the learned tribunal is stated to have been of the opinion that in the said case there was no interim order of stay granted to the direction.
Copy of the order is here, my lord.
The direction passed by the tribunal. This is evident from the copy of the order dated
27 January
2025 in Customs Miscellaneous Application 75753 of 2024, in Customs Appeal 75338 of 2024. As noted above, the court was convinced that this court was convinced in the case of Imami paper that substantial questions of law arise for consideration, and therefore the appeal was admitted. The necessity to grant an interim order did not arise in the said case, since the importer therein agreed to comply with the order passed by the first appellate authority, who directed destruction/incineration of the goods. However, in the instant case, we are of the view that the larger issue has to be decided, and also the applicability of the hazardous of the 2016 rules, and also the various decisions which were cited on behalf of the revenue, and in particular the decision of the division bench of the High Court of Madras in the case of ITC Limited versus Noracia Container Limited, 2008 SEC Online Madras 1161. Therefore, till the disposal of the appeal, the order and direction issued by the learned tribunal shall remain stayed. Full stop. An option is given to the respondent importer that if they are willing to re-export the cargo, the imported cargo which have been held to be prohibited goods in terms of the direction issued by the original adjudicating authority, they will give their consent in writing to the department, and if the same is given, subject to compliance of other formalities, the department shall permit the respondent importer to re-export the goods at their cost and risk, and cost, without reference to the pendency of this appeal.
Allow us to file
My
some
lord, the
documents, because
containers
this is not the entire record. We need to file certain more documents.
Learned advocate appearing for the respondent importer seeks leave to file a compilation containing all documents which are placed before the learned tribunal.
My lord, the containers are 54 in this appeal. In the next matter, It's a second,
67.
13.
13. Total 67.
Total 67.
Total 67, sir. Bracket 54 plus 30.
Two different appeals are there, my lord.
It will be a common order.
My. Grateful.
Condo. First paragraph. You get the Bombay judgment also.
I have.
And did you find out whether in this ITC matter what happened in Supreme Court?
That Supreme Court is also there.
You show the order. You you go through that single bench order.
I'll go through, my lord.
You go through. There may be something in your favor also.
They re-exported, and therefore.
They re-exported in this case, therefore. The direction number 4 was with regard to action against all officers, and those were there. So which is why that was only that portion was set aside since they re-exported the. ये होगा सब orders. Grateful, my lord.
94 days.
My lord, the delay has been 94 days delay.
But the next two matters,
What to do, sir?
well, only Mr. Mozumdar can help me. He can only seek an adjournment from the learned single judge.
Well, can we do it on Friday? Friday not possible. Then next Friday, madam. Next Friday, madam, somewhere.
Main in the list.
Well, next Wednesday, madam, I may not be available. That is why. There may be a difficulty.
See, what happens is we already upgraded.
Yes.
If it is missing on Wednesday, when it comes on Friday, somebody will come and mention. My lord, my matter.
But if it is appearing today as the upgraded matter, so it will appear as upgraded matter on Friday.
It will upgraded matter on Friday.
No, we will do it on Friday.
Very
Possible.
We will do it on
Very
Friday.
good. Very good.
But Wednesday, your lordship may kindly remember and accommodate, madam. If it is spills over to Wednesday.
Today we didn't expect the other matter to go on.
Yes, madam. Mr. Kundoli has let us all down. Where
Yes.
has he gone? And he was arguing all about my matter, Imami paper.
একটু ডিলেতে কিছু ফাইল করবি
Don't
স্টেটেড
That is why we gave that number.
But we are not opposing the application for condonation so far state's application.
No, it will not take up.
Right.
Lordship may mention lordship serial number 14 lordship appearing for respondent direct assessing lordship. Lordship, I will not be there on Friday and Wednesday. Can it be listed on next Friday, 21st, Lordship? 21st, Lordship. Obliged, Lordship.
And please inform the advocate for the department.
I will inform, Lordship.
Who's appearing?
Mr. Kundalia is
Anurag Roy.
Anurag Roy, Lordship. Mr. Kundalia would be arguing. I will inform, Lordship.
Yeah.
21st, Lordship, Friday. Obliged, Lordship.
Medical, questions of 1 year